Yes, Mr.
My lords, my lady, I appear today on behalf of the Appellant Secretary of State for the Home Department with my learned friend, Miss Julia Smythe. My learned friend, Mr. Simon Cox, appears with Mr. Martin Spencer on behalf of the respondent, Ms. Akinsanya. Housekeeping, first of all.
Just before you do any housekeeping,
Yes.
this is not my usual court, and the chair is an uncomfortable height. I'm just going to see if I can adjust it. This may turn out a bit of a mistake. This is very undignified and shows how... No, I should have said strongly uncomfortable. That's fine.
Oh, no, I'm sorry.
Your advocacy will distract me.
I hope in a good way, my lord. My lord, housekeeping. Your lordships and your ladyship should have an appeal bundle with 8 tabs running to 115 pages. That's the core bundle. Then there's a supplemental bundle with 30.
Well, yes. Can I just say, and this is a real... I have a core bundle that actually runs to 128 pages.
Ah.
And no tab.
And the point I was about to make, no tabs.
No tabs.
And this is really quite irritating. It's true, one can always find it by the page numbers, but it is useful to have tabs.
Yes.
The council always say, oh, tab so-and-so, and
yes.
nobody has given us any tabs. So could those behind you who are responsible for putting the bundles together
take note of that?
Yeah.
My lord,
that's perhaps more importantly.
Your lordship has 13 more pages than me.
Yes, I think what's happened is that... No, I can't, no, there's no obvious explanation. I thought there was.
Can I just ask what your lordship has beginning at page 116?
116 is halfway through the claim form.
Claim form.
We have core bundle. Last item is claim form and grounds of claim.
Yes.
23rd December, 9 pages 96 to 128, and that's the end of the bundle.
Well, I am slightly taken aback by that because in my bundle, and certainly that of Miss Smythe, we have the claim bundle beginning at page 83 and finishing at page 115.
Well, this is a nuisance, I think, but
yes.
This isn't a incredibly document-heavy case. We will manage.
Yes, I'm
but
very
again,
sorry.
No, let's have a post-mortem afterwards.
Yes.
Something's gone wrong, and I think it's worth finding out, not to give someone a hard time, but to make sure it doesn't happen again. Are you in the same boat, Mr. Grant?
My lord, it seems that we have the same papers as my learned friend and not us as the court.
Well, there we are. Okay, we'll manage. Yes. Well, that's that bundle.
Well,
what are the other ones we're going to look at this evening?
I hope again I'm slightly better with the next bundle. The next bundle is the supplementary bundle.
Yes.
Now that should have 30, well, you won't have tabs, I'm sorry, that should have 166 pages.
No, it has
171.
171.
Well, I can only apologise. I'm extremely sorry about that.
No, what are we missing?
Well, that's what I'm wondering.
None of this matters very much if we have the same things, but maybe you have things that we don't.
Well, it sounds like it might be the other way around, my lord, that the court has certainly more pages than the parties do. Now, it may be that there's been some duplication between the bundles, but I certainly wasn't aware of any issue.
Let's not spend any more time on that. Anything you want to refer us to, we'll have to sort out when we get there.
Yes. In reality...
anything, as I think you pointed out, it looks as though we got too much rather than too little, so it's unlikely that there's anything missing.
Yes. I can probably, I hope, be helpful and indicate this at the outset. Certainly in terms of the core bundle, the 2 documents I was going to be referring to at some stage in my submissions were the chronology and the judgment itself, of course, Mr. Justice Mostyn. So it may be that we can identify those.
Let's just get on. We've identified there is a problem. We will resolve it when we, so far as necessary.
I better just check though that the authorities bundle
Yes, no, you better
the same sort of defect.
That does have tabs, which is helpful. We have 24 tabs.
Excellent. Well, we're on the same page on that. And my lord, again, we'll conduct the post-mortem afterwards, but my apologies to the court for that. So, my lords, my lady, this is, of course, the Secretary of State's appeal against the decision of Mr. Justice Mostyn sitting in the High Court, dated the 9th of June, 2021, in the parties bundles. That is in the core bundle beginning at page 35. I hope the court has at least a table of 48, right. I'll make a note. the table of contents. By that decision, the court will have seen that Mr. Justice Mostyn allowed Ms. Akinsanya's claim for judicial review of the Secretary of State's decision of the 29th of September 2020. Now, again, in my bundle, in the supplementary bundle, that begins at page 62. There's no need to turn it up, but the court will, I imagine, want to look at it at some stage.
Sorry, this is the decision.
So that's the decision. It's just for the court to note, it's at page 62 in the supplementary bundle. But
Yes, no, I've already.
you have that. And that was maintained by a reconsideration decision dated the 23rd of November 2020. And again, in the parties bundles, that begins at page 66.
Yes.
I've been less diligent. I haven't looked at the reconsideration decision, but it doesn't say anything substantive.
No, nothing turns on those decisions. I wasn't going to spend any time going to them.
No.
The court will have seen that there are two issues in the appeal. Issue one, ground one, is in effect, does a Zambrano right of residence arise in circumstances where the putative beneficiary holds a domestic law right of residence? You'll be aware here that Ms. Akinsanya held a right of residence under Appendix FM of immigration. And the second issue is, if so, can Regulation 16 of the 2016 regulations be read consistently with that interpretation? Now, for the appeal to succeed...
Is that, that's a slightly tendentious way of putting it, isn't it? The route we get here is... well, the first point is that actually all this depends on the terms of the immigration rules, the actual right we're arguing about, that's correct, isn't it? And on the definition.
Yes, on the definition, which refers to regulations as well.
Are you going there?
I will be.
Yes. Okay.
Yes. It does.
The point. Carry on.
Well, the way I was going to put it was, and this is the way I was going to order my submissions, I was going to begin by, after I've dealt obviously with the Secretary of State's case in a nutshell, the facts and the law very briefly, take your lordships and your ladyship to the relevant case law, so a series of decisions in the CJU and one decision domestically, which in my submission demonstrate what the true extent of the Zambrano right is. Now that's the first point I need to establish, because if I'm wrong for the Secretary of State in what in fact, in substance, the Zambrano right amounts to and extends to, then ground one fails, and in effect, ground two won't arise in those circumstances. But if I'm right about ground one, then in my submission, one has to see whether the regulations, for it is the regulations that have, on the face of it, the narrower interpretation, whether they can be construed compatibly with that analysis. Now, the other point I was going to make in opening was this. It is true, and I think both parties have made reference to this at different points in their pleadings and skeletons, that for the appeal to succeed outright, we have to win on both those points. That doesn't mean there is no value in the first ground alone. So if I can put it like this, if the Secretary of State is wrong about the proper analysis of Zambrano, she needs to know that, because it will affect how then she responds ultimately to the upholding of Mr. Justice Mostyn's decision. There is a separate question as to whether or not the regulations can be read according to a conforming interpretation, a la Marlise.
Is this right? If you lose, full stop, that's more particularly for the point I put you, if you lose on ground two, because Reg 16 means what it appears to say.
Yes.
You still need to know what the underlying Zambrano law is, because that will affect the choices that the Secretary of State makes in deciding what to put in its place.
Exactly. That's exactly the point I'm making, my lord. Your lordship's put it much more eloquently than I could. We need to have an answer, come what may, on ground one, for the purposes of any remedial considerations afterwards. So even if the court feels that it cannot construe, reaches the conclusion it can't construe Regulation 16 in the way the Secretary of State says it can be construed, then it's still of real purpose and utility for the Secretary of State to know whether the answer to question one is as she says. I'm very grateful. So, my lords, my lady, can I begin then with the Secretary of State's case in a nutshell on both grounds, just so the court has in outline what I'm proposing to say. On ground one, 5 short points which encapsulate our case. First of all, the Zambrano right is, in my submission, a creation of the CJEU. Its objective is to ensure that all
Well, hang
EU...
on. If these are your key points, you'll have to do the dictation speed.
I'm sorry, my lord. Shall I repeat that again?
Yes, true.
The Zambrano right is a creation of the CJEU.
Yeah.
Its objective is to ensure that all EU citizens are able to enjoy the benefits of their status as EU citizens.
Yep.
Well, that's point one. Point two, as a result, the right requires third country national carers of EU citizens that's usually, obviously, adult carers of minors, but it can be adult carers of other vulnerable adults, as we know, to be granted limited residence and working rights where they do not otherwise have such rights.
Yep.
Thirdly, the reason for that is to prevent the EU citizen being compelled to leave the territory of the EU.
Yep.
Fourth point, the focus, therefore, in deciding whether Zambrano right arises is on the question whether the EU citizen would, if the right is not granted, have to leave the territory of the EU. And then fifth and final point on ground one, it's frequently been acknowledged as an exceptional right arising, as it does, in a situation which would otherwise be characterised as wholly internal, for those reasons and in that situation, if the EU system would not otherwise have to leave the territory of the EU, be compelled to do so in limited cases, then there is no need or justification for that right. And ultimately, that is why, if in this jurisdiction a person has an existing domestic law right of residence, the Zambrano right will not arise. It serves no other independent purpose. It's a classic...
Not quite as simple as that, though, is it?
Right.
Because suppose you had a domestic right, a right under the immigration rules, but no right to work. You would have a Zambrano right to work, but you wouldn't need a Zambrano right to reside. Is that a realistic scenario? If you had, say, 6 months leave with no right to work, that is a creature you can have, isn't it?
Without a right to work?
Maybe not. Maybe it would never happen in practice.
I'm sorry, my lord, to turn my back just for a moment. My lord, the position as I thought it was is that would depend on the circumstances. So, in principle, it would be open to somebody to apply to lift the restriction, if there was a restriction, for example, on working, if it was a domestic law right.
Yes, but factually, although typically, if you are given the kind of leave that may lead ultimately to settlement, you get the right to work at the same time. But the Secretary of State can impose any conditions they like in principle.
Yes.
And with short-term forms of limited leave, for example, some sorts of discretionary leave, they are not accompanied by by a right to work.
Well, that might be right, but of course...
Yeah, no, okay, so the point I'm making there is,
Yeah.
supposing you were also in that situation a primary carer,
Yes.
you wouldn't, quote, need the Zambrano right to reside, but you would need the Zambrano right to work.
Well, in principle, that might be right, but it would be open in such a case to say, I need to have my right to work lifted. And of course, the position
But the
is...
Secretary of State might say, no, I'm not going to do that, and then you'd have to rely on your Zambrano right.
My Lord, the Secretary of State might say that, but of course, if the Secretary of State was faced with a position where the alternative was a Zambrano right arising, it might be that the Secretary of State would take the alternative position in order not to give rise to the Zambrano right. If the Secretary of State
suppose what
grant
I'm
the right
just trying to
work,
tease out is what exactly is a Zambrano right?
so Zambrano right...
It's not... I mean, it's a creature entirely of the court.
Yes.
And it has at least two elements which appear from Zambrano itself. One is the right to reside, because if you're not there, you can't do your caring.
Correct.
The other, perhaps more controversially, but one sees the thinking, is it also have the right to work, because the court obviously took the view you might not be able to do your caring unless you could earn.
Yes.
We also now know, at least at our level, I'm not sure it's ever been decided at the community level, you don't have the right to benefits.
Correct.
But it's not, it's a right whose content may change depending on the circumstances.
Well, my Lord, yes, but it has only ever been, in terms of substantive content, determined by either the courts here or in Luxembourg to contain those two key elements that my Lord indicates. So the right to reside, which of course is absolutely fundamental. Without that, nothing else really matters, and the right to work. So, as my Lordship says, of course, we know from the Sino NHC litigation, there's no right to benefits, and Zambrano carers are excluded from mainstream benefits. That's why, of course, Ms. Akinsanya ultimately applied when she did for the Appendix FM.
No, I understand all that.
Yeah.
Okay, there's always a risk if you trail your points beforehand that we start asking questions about them before you've had a chance to develop them. The only point I just wanted to flag up was that it's enough really to make the point the Zambrano right has two elements,
yes,
and there could be situations in which you need one and not the other.
Yes, my Lord, I understand my Lord's point. My response to that is it would be open to the Secretary of State to respond on the domestic level by granting a right to work if the right to work had been previously excluded. So in other words, if there was an initial grant of leave under a different provision of the rules which carried a no work condition, then it would be open to the Secretary of State ultimately to lift that. Now, I'll take further instructions on when such a condition might be imposed. My Lord's given the example of discretionary leave. It certainly used to be the case, and I think it still is the case, that asylum seekers, usually any temporary leave they may have, if they're on temporary admission, for example, that would carry a no work condition as well.
Well, it'd be useful to know, but I'm really...
Yes.
But basically, my point is a conceptual one rather than depending on how often this was
Yes, no, I understand that.
Okay.
And I hope the conceptual answer is that can be dealt with domestically as well
But then, so can the right to reside be dealt with domestically? So
yes, but my Lord, that's the point. Where the domestic law deals with it, in our submission, of course, it doesn't arise under EU law, then it's an issue.
Your point really is that EU law is there to fill the gap.
Yes. My lady, that's exactly it. And that the first provision I'm going to take the court to is Article 20, because that is what creates the need to fill the gap. And that's interpreted in Zambrano and the cases which follow. But that's exactly the point, my lady. So, my lords, my lady, that's my case in a nutshell on ground one. On ground two, again, 4 short points on this. There's no dispute, first of all, that the domestic regulations, and specifically Regulation 16, on their face only expressly exclude someone with indefinite leave to remain. But secondly, the EU law question, the reasons I've outlined and we'll deal with in more detail, applies so that anyone with limited leave to remain would also be excluded.
Sorry, say that again.
And the EU law question applies so that anyone with limited leave to remain would also be excluded. The third point then is that this is not a situation in which it was intended that domestic legislation should go further than EU law. And then fourthly, we say the well-established case law on conforming interpretation, which we've summarised in our skeleton, indicates that conforming interpretation here is both possible and appropriate. That's my case on both grounds, just in a nutshell, so the court has an idea of where I'm going. Can I deal very briefly with the factual background? And to deal with this most briefly, I think the easiest way to do it is by reference to the chronology. And this was a chronology first provided by the claimant and added to by the Secretary of State. I don't think there's any real dispute about it at the moment. I think this may be at page 37.
Well done.
Yes. Yes. Very grateful to my learned friend, Ms. Smythe, who has managed to work out what the page number should be. And it looks to me as if there are a couple of items that your lordships have that are not in the bundles that the parties have. I'm sorry about that. Anyway, page 37. And your lordships and your ladyship will see Miss Akinsanya is a national of Nigeria. She arrived...
We need this degree of detail. This is a good, helpful chronology. There's obviously a complicated history over the first few years.
Yes.
But all of which is actually irrelevant to the point
It is.
in this case.
Well, I'm very happy to skip over that entirely.
My lord and my lady.
I didn't want to presume to do that before.
No, fair enough. No, I think
but I take the point.
really the factual
Yes.
points are very narrow for this case.
My lord,
And not disputed.
no, absolutely. My lord, in that case, can I go straight to the law?
Yeah.
So legal framework, and again, there's relatively little dispute, if any, really, over the legal framework. So I can take that rather quickly as
Yes.
well. Your lordship's senior ladyship will need the authorities bundle for this, which thankfully we all have the same numbers for. The original position in terms of derivative rights domestically is set out behind tab 2 in former regulation 15A of the 2006 regulations. This sets out the position in terms of derivative rights in domestic law prior to the Zambrano decision. So you won't see an enactment of Zambrano in there. What you then have, though, is amendment of that provision in 2012 by the statutory instrument behind tab 1.
Wait a moment, sorry.
So tab 2 is the Immigration EEA Regulations 2006. There, if you like, the starting point domestically for the enactment of derivative
Sorry, rather
rights.
confusingly, I'm sure this is right. It says version 1 of 5, 16th July to 2012 to 7th of November.
That's right. So on the 8th of November, it's amended by the instrument at tab 1.
Right.
So this is to show the court how Zambrano first came to be, if you like, enacted in law domestically, how effect was first given to the Zambrano judgment domestically. So if the court then turns to tab 1, you'll see the Immigration EEA Amendment number 2 Regulations 2012. And then at page 5, you'll see Regulation 3 makes amendments to Regulation 15A of the then 2006 regulations. You'll see subparagraph A, so that's a reference to exempt person. And the definition of exempt person is then inserted by paragraph C2. And paragraph B of that regulation 3 inserts a new subparagraph 4A, which is in effect, well, which was intended to give effect to the Zambrano judgment. Now you will see P satisfies the criteria in this paragraph if A, he's a primary carer of a British citizen, the relevant British citizen, B, the relevant British citizen is residing in the UK, so in other words, somebody who's not exercised their right to move, and C, the relevant British citizen would be unable to reside in the UK or in another EEA state if P were required to leave. So that's the wording that's introduced.
Just remind me, what was the date of the Zambrano decision?
Zambrano decision now was the 8th of March 2011.
So there was an interval of 18 months or so,
Yes.
during which the Zambrano right was operative, but not reflected in any domestic legislation.
That's correct, my lord.
Do we have anywhere a copy of what the regulations actually looked like with these amendments, so that one can see at a glance what the scheme looked like before the latest amendment?
I'm afraid we don't. What's happened is we've got, we have a copy printed, and the juniors thought of that point already.
Yeah.
I can hand that up if that would assist.
That would be helpful.
Very grateful to her.
Thank you, Ms. Meyer.
Usher.
Yes, you'll see turning over to page 2. So perhaps I can just ask the court to look at paragraphs 1, 4A and 6.
Just before we do that, just so I can get this clear in my head, the original version, which you showed us at 2,
Yes.
This was the first time that a Regulation 15A had been introduced. Is that right?
Correct.
And it was introduced to introduce something called a derivative right of residence.
That's right. So those are rights such as arising from cases like the court may have come across before, like Chen, Texira and Ibrahim. So rights deriving from the rights of primary EU citizens.
So this too was in order to respond to
Yes.
case law of the court,
Exactly.
but not at that point Zambrano.
Not at that point, Zambrano.
And it's maybe lost in the mists of history, but Zambrano, this was introduced in July 2012, by which time Zambrano was over a year old.
Yes.
Why wasn't Zambrano dealt with in this first 15A when all the other derivative rights of residence were?
Can I come back to your lordship on that? I see the point. I would need to take instructions on that. It wasn't, as your lordship has already pointed out, it was, Zambrano was out for some time before it was dealt with in the regulations, but not dealt with at that point.
So what's the change between July 2012 and November 2012, which we need to note?
So the change is-
15A brackets 2 looks the same.
2 is the same, but if you're looking at the version I've just handed up, you'll see in 1, in square brackets, an exempt person is introduced. And then over the page, you'll see 4A, subparagraph 4A is introduced. That's the key provision for Zambrano purposes.
Yes.
And then there are also amendments made by the insertion of a definition of exempt person in subparagraph 6. And you'll see subparagraph 6C4 refers to indefinite leave to remain.
But C1 speaks to somebody who has a right to reside.
As a result of any provision of these regulations, that's right. So it wouldn't be a right to reside at large in immigration, it would just be under those regulations.
So sorry, I was a bit slow, so I was writing something down. So the changes are
Yes.
the reference to an exempt person in 1, which is instead of the formula not entitled to reside in the UK.
Yes.
And then presumably the definition of exempt person, which comes in for the first time at 6C.
Correct.
Then what else do we need to see?
So 4A.
And 4A, obviously, sorry.
4A, yes. There are additional amendments made, so the amending regulations inserted also 7A and 7B, but nothing turns on them for the purposes of this case, shared parental responsibility. Now, that was an issue in some other case law for this court, but it doesn't arise here, it's not an issue.
Now,
but my Lord, I can come back with a short answer on the point my Lord just raised, which...
But it probably doesn't, I wouldn't mind having it. It's just
Yes.
I can get it all clear in my mind.
Yes.
Yeah, I can see it almost certainly doesn't bear on the particular issue, unless one feels firm ground beneath one's feet.
Of course.
Yeah.
So, my Lord, and this reflects, the note I've just been given reflects my recollection of what was happening at the time, but I wanted to make sure that I wasn't misreading the position. The position was at the time that these original amendments, so the original 15A was introduced, dealing with Chen, Texera, Ibrahim, the response by the government to the Zambrano decision, which I'm sure the court will appreciate was quite a controversial decision at the time, was still being discussed internally, particularly, for example, with regard to the benefits position. And again, the court will be aware of litigation in this court and beyond on benefits in relation to Zambrano. So the government wasn't in a position to implement the necessary changes with regard to Zambrano. With regard to Chen, Ibrahim, Texera, those are older decisions of the Court of Justice. And so by that stage, the government was in a position to implement and amend. So the government moved forward with what it could, knowing and understanding that the amendments for Zambrano were perhaps more controversial and going to take a little longer to deal with. That's why there was a delay. As I say, that I have had this question come up in another case, and that coincides with what I recall being told.
Well, unless anyone tells us the contrary, that seems understandable.
Yes.
One question I wanted to ask,
Yes.
and maybe you're going to come to it, in which case just tell me and I'll wait, is that what is created by 15A is a derivative right to reside. Now that language isn't the familiar language of the Immigration Act, which talks about leave to remain.
Yes.
And it doesn't really say what the content of a right to reside is, although we haven't got it, I think, or if we have somewhere else. The definition section simply says a derivative right to reside means a derivative right to reside as defined in these provisions, so it's circular.
Yes.
And again, to say it's bare paper, you haven't printed out the whole of the regs, which is fine, but I've looked at it I've looked at the whole of it. There are some substantive provisions about how procedural, how it can be taken away, appeals, all that sort of thing, and the right to a residence card.
Yes.
But there's nothing else saying what a derivative right to reside is. You've just got to take it literally. It is a right to reside, which means, by definition, you can't be made to leave.
Exactly, and in a sense...
It's a bit puzzling. Can you help me conceptually why the machinery of leave to enter wasn't used?
Because, my Lord, at that point,
Or leave to remain?
Leave to remain. Section 7 of the Immigration Act 1988 was still in force. And that's not in the bundles, but that provided, in effect, that those persons with rights arising under EU law did not need leave to enter or remain in the United Kingdom. So the EU position was taken out of the conventional immigration position by Section 7 of the 1988 Act. Now, that's a provision that's come up in other cases. It's not relevant here. My Lord is absolutely right. There's no substantive definition in the regulations as to what a right to reside is. In effect, it's in some ways defined by absence or defined by exclusion. So you do have provisions in the regulations dealing with when you can terminate a right to reside. And my Lord may recall there was a case a couple of years ago before my Lordship, Robinson, which ended up going to the Supreme Court. We have the Supreme Court decision here about the Court of Justice's decisions in Rendon, Marin and CS Morocco. And that was all about when you can not grant a Zambrano right or restrict a Zambrano right because, for example, of serious criminality. So right to reside would be construed in accordance with the European case law, of course. In a pre-Brexit situation, that would be straightforward. But my Lord is absolutely right.
Sorry, just coming back, you said you didn't use concepts of leave to remain because a particular statutory provision, section, what was it?
It was Section 7 of the Immigration Act 1988.
Took the whole concept of EU citizenship out of the immigration.
Yes, I don't have the
out of the Immigration Act 1971 machinery. Is that right?
In effect, that's right. What it said was that if you had a right, effectively a right of residence arising under EU law, you didn't need leave to enter or remain.
And it was arising under EU law rather than for EU citizens. Because, of course, a Zambrano carer isn't an EU citizen.
No, that's right. That's right.
Okay.
And of course, the citizenship provisions and the treaties have developed over time.
No, I understand that. Okay, thank you. So that explains why we're dealing with a different kind of animal.
Exactly, and there is some case law about how the various orders and regulations have developed over time, but certainly by this stage they were outside the standard provisions that the court will be familiar with from non-EU immigration cases. Now, my lords, my lady, can I just show the court also what it was that was intended to be done when those amendments in 2012 were made? You'll have seen reference in the party skeletons, the explanatory note and explanatory memorandum. We have those in the bundles. They're at the back of the regulation. So at page 7...
And now we're talking about...
So this
when
is
you say done in 2012, you mean in November 2012, not July 2012?
Yes, exactly, my lord. I'm sorry, of course.
Yeah.
November. That's absolutely right, November. So from 8th November 2012, in tab 1, page 7, you will see the explanatory note. Can I just ask the court to read the first 2 paragraphs? My lords, my lady, can I just highlight one passage in those 2 paragraphs? You'll see just below the second paragraph begins at the second hole punch, and you'll see 4 lines in where the denial of such a right of residence would prevent the British citizen from being able to reside in the United Kingdom or in an EEA state. We said that's an accurate reflection of what Zambrano is about, but it is slightly different from the wording obviously in the regulations. Then you have the explanatory memorandum over a couple of pages at page 10. You'll see the purpose of the instrument at paragraph 2. Paragraph 2.2, the regulations give effect to the judgments of the CJU, the ECJ, as it was then being referred to. in the case of Rahman and Ruiz Zambrano. And 4.1 legislative context and 4.2 regulations give effect to judgments in Rahman and Zambrano. And then you have the policy background at 7. And you have at 7.1 reference to the amendments that were made in July that the court's already seen to deal with Chen, Ibrahim, Teixeira. And then 7.2 is the one that's relevant here. It says this: further amendment to the regulations is now required in order to give effect to the ECJ judgment of Zambrano. That judgment created a further derivative right to enter and reside for the primary carer of an EU citizen who's living in his or her own country, and where a refusal to confer such a right would force the EU citizen to leave the EU. EEA. Now I pause there. That, of course, is an early indication of the language of compulsion or obligation. I'll be coming back to make submissions on that, but that, we say, is an entirely accurate reflection of what Zambrano is about. It continues, in the UK, the judgment therefore enables a primary carer of a British citizen to acquire a right to enter and reside in the UK whilst they remain the primary carer of that British citizen, and where the refusal of such a right would force the British citizen to leave the EEA. Again, we say the language of force is entirely consistent with what the cases have shown a Zambrano right to involve. Now, that is slightly different language from the language actually used in the regulations. I have to acknowledge that. I don't make any bones about that. We've been clear about that. But we say that's the purpose that was being pursued by these statutory amendments, and that is a correct reflection of what Zambrano is about.
These all these roads were made under the under Section 2.2 of the
Correct.
1972 Act. Yeah.
Yes, that's right, Mother. That's right. Well, then one has the tab 3, the 2016 regulations, which effectively repeal and replace the 2006 regulations. If the court turns to page 20, you'll see Regulation 2, which is a general interpretation section. There's a lot of familiar definitions there. Just for the court to note, at 22, you'll see that indefinite leave, immigration laws and immigration rules have the meanings given in Section 33.1 of the Principal Act, the 71 Act.
Yes, and in fact, I see we do have the definition above on the facing page above the whole bunch. Defining a derivative right to reside simply in terms of Regulation 16.
Exactly.
Yep.
Exactly. And then my Lord has Regulation 16 at page 25. It's obviously been cleaned up, as it were, in the earlier versions. Paragraph 1, the person has a derivative right to reside during any period in which the person A is not an exempt person and B satisfies each of the criteria in one or more of paragraphs 2 to 6. So 2 to
I'm not stopping you taking us through this, but just so to be sure. This is identical to 15A as amended in November. Is that right?
For the purposes of this case, that is right. Yeah. That is right, yes. Materially the same.
So in particular, the definition of exempt person is the same.
Yes, exactly. That's right, Mother.
That's the critical paragraph.
That is. And indeed also paragraph 5, subparagraph C, BC would be unable to reside in the UK or another EEA state if the person left the UK for an indefinite period. See, that's also relevant.
And we've been given version 3 of 4. Just for form's sake, we're looking at the position at the time of the challenge decision, which falls into this period, is it?
Yes, that's right.
Yep.
So the original decision was 29th September 2020.
Yes.
And reconsideration was 23rd of November 2020 as well.
Yeah. Right.
And after that, of course, the regulations are repealed, subject to certain very limited savings, which I won't go through now. Then the final piece in the legal framework, jigsaw, if you like, is the EU settlement scheme, Appendix EU to the immigration rules. a very complicated appendix, even by the standards of the immigration rules.
Yes.
I know that this court has commented on that before. I won't go there. It usually ends up very badly for the advocate for the Secretary of State, in my experience. But for the court's note, the relevant provision for today's purposes is EU 11 at page 31. EU 11, the applicant says this for persons eligible for indefinite leave to enter or remain as a relevant EEA citizen, or a family member, or a person with a derivative right to reside, or with a Zambrano right to reside. Perhaps I can just let the court read that paragraph of EU 11 at the bottom of the page. And then over the page, the relevant condition is that in paragraph 3. And you'll see 3A5 is a person with a Zambrano right to reside, or who had a derivative or Zambrano right to reside.
And where's that phrase defined?
And that phrase is then defined later on at page 61. At the top of the page, we'll see person with a Zambrano right to reside defined there. Person satisfied the Secretary of State, including where applicable by evidence of family relationship, that by the specified date they are, and for the relevant period have been, or as the case may be for the relevant period in which they rely on that status, they were A, resident for a continuous qualifying period in the UK with a derivative right to reside by virtue of Regulation 16.1 of the regs. That's why I wanted to take the court to Regulation 16 to begin with, by satisfying Roman 1, the criteria in para 1A, that's not being an exempt person, and 2, the criteria in, and then there's alternatives, AA is paragraph 5, and then B, without leave to enter or remain in the UK, unless this was granted under this appendix.
I was puzzled when I first read this, and I think it ought to be clear, but perhaps you can just spell it out for me. Why isn't it a straightforward answer for you in this case to say B isn't satisfied?
Well, that would be a very short and neat answer for me, but I think the response from Mr. Cox would be you have to construe that according to what Zambrano actually means. It's intended to give effect to Zambrano. And if you've got that wrong, then in effect, B wouldn't help you.
Now, I think that's. I think that must be right. It's always proceeded on the basis that this all depends on. I know why you want the answer about Zambrano, because you say it informs the answer about Regulation 16, but actually, formally, this has proceeded on the basis that it all depends on Regulation 16 and what it means. In other words, on round 2.
Yes.
You say in order to answer round 2, you've got to answer round 1.
Yes, exactly.
But just following through the definitions here, the point for the claimant, which you do not dispute, is you can't just rely on B, because A involves you having a derivative right to reside under Regulation 16.
Exactly, and they are cumulative. So it's A and.
Yeah. Okay, I certainly not wanting to take a point that
Yes.
you haven't taken. I just wanted to understand why it hadn't been taken. I think I'm.
No, that's right. And my lord, there is some discussion of a related point. I'm not proposing to take the court to it, but can I give the court the reference in paragraphs 13 and 14 of the witness statement of Mr. Adam Lamont? Oh, I'm sorry. Oh, I see. Sorry, my lord, ignore me for the moment. I was giving the wrong reference. Sorry, I had something handed up to me, but it was something different from what I thought. So, my lord, that's the answer on that point. I hope that assists.
Yeah.
My lord, with that brief background, then I can turn straight to my submissions and go to ground 1. And what I was proposing to do under ground 1 was to take the court to 3 sets of material. Article 20, first of all. And secondly, a series of CJU cases, so Zambrano, Chavez Vilches and KA, and in cases called NA and IDA. And then thirdly, the domestic case of Shah and Patel in the Supreme Court. And after I've done that, I will then make some brief submissions. I'll make submissions as I go through about what they show the Zambrano right to include and what it doesn't include. And then I'll take you to Mr. Justice Mostyn's judgment, if I may, and deal with 1 or 2 points in Mr. Cox's skeleton. So can I begin with Article 20 of the TFEU? It's not in the bundles as a separate provision, but it appears throughout the cases. And you can find it perhaps most conveniently in the Advocate General's opinion. This is Advocate General Sharpston in Zambrano itself. Zambrano is behind tab 6 of the authorities bundle. And Advocate General Sharpston sets out Article 20 in paragraph 6 of her opinion at page 131. And you will see there, Article 20, Para 1, citizenship of the Union is established. Every person holding the nationality of member states is a citizen of the Union. Citizen of the Union is additional to and doesn't replace national citizenship. And then 2, importantly, citizens of the Union shall enjoy the rights and be subject to the duties provided for in the treaties. Might also be worth just flagging up there Article 21, which is below that, which says every citizen of the Union has the right to move and reside freely within the territory of the member states, subject to limitations and conditions in the treaties and the measures adopted to give them effect. So my submission on that, short submission, is that possession of EU citizenship entails enjoyment of the fundamental right to move and reside freely within the member states. You see that from the combination of Article 20 and Article 21. So if you are an EU citizen, you have those rights and you're entitled to enjoy them. As I say, the right of free movement in Article 21 is perhaps the most fundamental of them, certainly in the way that's been examined by the court's case law, and that is what falls to be protected. It stands to reason, of course, that if you cannot reside within the EU because you've been forced or compelled to leave, then you cannot ultimately enjoy that fundamental right. That's, if you like, the protection gap that my lady referred to in my opening a moment ago. So that's Article 20, and that's all I need and want to say about that. Can I go then, second part, to the CJU cases? And again, perhaps conveniently, we'll start with Zambrano. The reason I'm taking you to the 3 sets of cases, can I headline this point? I'm taking you to Zambrano to begin with to show how the CJU conceived of the nature of the right, and also to examine one matter of fact that played heavily in Mr. Justice Mostyn's decision. Then, when I go to Chavez Vilches and KA, it will be to show the centrality of the concept of compulsion, which is significant here. And then finally, when I go to A and IDA, it's to show the relevance, significantly for this appeal, of the existence of other rights of residence. So can I move to Zambrano? And the submission here, again at the outset, is that a particular right of residence where no free movement rights have been exercised is needed to protect EU citizens who depend on others for their presence in the EU if they would otherwise be forced to leave. And the reason is that departure would entail the practical loss of the genuine enjoyment of their rights as EU citizens. That's Zambrano in a nutshell. Now, I wouldn't normally go to the facts of Zambrano, because I know that's a decision that would be very familiar to the court. I'm going to here, if the court will bear with me, just as I say, because there was a bit of an issue about some of the facts as Mr. Justice Mostyn saw them. They are dealt with in detail at paragraph 18 and onwards of the Advocate General's opinion. And you will see there, paragraphs 18 to 20, that Mr. Zambrano arrived in Belgium from Colombia with his wife and initially claimed asylum. His asylum claim was refused, paragraph 20, by the Commissariat General for Refugees and Stateless Persons, but it added a non-refoulement clause stating that his family and he should not be sent back to Colombia in view of what was described as a critical situation, effectively a civil war. He nonetheless applied for a residence permit later on in 2000, October 2000, that's paragraph 21, and made 2 further subsequent applications after the birth of his children. All 3 applications were refused. You'll see in 23 he obtained full-time employment. Paragraph 20, sorry, I'm just looking for the first reference to the first child.
Brought the first child.
They brought the first child with him, exactly. That's paragraph 19, exactly. He'd been abducted in Colombia. So he came with him in paragraph 19. 25, the second child, Diego, was born, and the third then 2 years later. So by 2005, all 3 children were there. Both those latter 2 children were born in Belgium, and so they had Belgian nationality. And you'll see what's said at the end of paragraph 25 about the effect in Colombian nationality law there. And they were enrolled in schools in Brussels, in Schaerbeek district. Paragraph 27, or 26, describes how they gave rise to the second and third applications. 27, as a result of the third application, the Belgian authorities issued a decision granting Mr. Zambrano a residence registration certificate covering his stay for that period. Following his appeal against the various decisions refusing him a residence permit, Mr. Zambrano's stay was covered by a special authorisation pending final determination. So he was protected.
Is it important that we understand the difference in a residence registration certificate and a residence permit? If it isn't, I won't trouble you, but
I don't think anything is going to turn on that here, in this case. I'll come to some further provisions that are referred to later on about their status. Then his employment contract, you'll see at paragraph 28, was temporarily suspended, and he applied for temporary unemployment benefits but was refused. And he was recruited again to work, you'll see at the end of paragraph 28. Then in paragraph 29 is a description of there being a workplace visit, effectively. It was found that he didn't have a work permit, and so there was an order issued to immediately terminate his employment. Paragraph 31, he again applied for full-time unemployment benefit but was refused. And he brought an action before the Employment Tribunal in Brussels. And then 32, you'll see in its written submissions, the Belgian government states as a result of the government measure to regularise specific situations of illegal residence. In 2009, Mr. Zambrano was granted a provisional renewable residence permit, and that's why I said a moment ago in answer to my lord that nothing really turns on that point here, because he got a renewable and provisional residence permit as well as a work permit. That appears to have been as a result of some sort of amnesty in 2009. But the latter does not have retroactive effect significantly. And Mr. Zambrano's employment is still considered, in that period from 2001 to 2006, is still considered as not being covered by a work permit. Now that is relevant for why it was necessary for the court to go on and deal with the issue, because there is a suggestion, and I'll come to it when I look at Mr. Justice Mostyn's judgment in more detail, but there is a suggestion that in some way the fact that he had a residence permit meant that the court must have tacitly been accepting that the existence of a right of residence domestically was irrelevant for Zambrano purposes. Not so. It was critical for the court to examine the position for that period, because that's the period that mattered for his claim for an employment benefit. As I say, I'll come back to that when I go to Mr. Justice Mostyn's decision, but so that the court has those points here. There is more detailed discussion about some of the issues arising from that, but I don't seek to go through it. But for the court's note, that's in the next preliminary matters section of the Advocate General's opinion at paragraphs 36 through to 44. But I don't seek to go through that in any more detail. So I'm grateful to the court for bearing with me, going through the facts in a little bit of detail there, but hopefully the court sees why I needed to do that. Now, the point is then picked up in the judgment really at paragraph 33, and that's at the law report page 316, bundle page 176.
Yeah.
And you'll see there the court saying that it's apparent from the order of reference that the two decisions which are the subject matter of the proceedings.
Sorry, where are you reading?
Sorry, paragraph 33.
Yep.
33, my lord. Yep. For which the Employment Office refused to recognise his entitlement to benefits, unemployment benefits, first during a period of temporary unemployment from.
I mean, how much are you going to?
Well, can the court just read 33 and 34? That's all. And again, that's really just so that I don't have to go back to this when I go to Ms. Justice Mostyn's decision in due course. And then the critical analysis, and again, these are passages which the court will be familiar with, is at paragraph 39 and onwards. Just so the court has it in its mind, can I ask the court to read 39 to 44? I'm grateful.
Out of curiosity, did that reasoning accord with that of the Advocate General?
Well, not in part. The Advocate General also engaged in a very detailed analysis of discrimination. And that's what you don't find in the court's judgment. That was a very significant issue in the Advocate General's opinion. So what the court took forward was the narrow analysis based on Article 20, not looking at discrimination in terms of EU nationals.
Thank you very much.
The focus, you say, is all on the national of the citizen of the EU, in this case the minor children, and the impact that refusal of the rights to the carer parent, in this case, would have upon their rights. And if you refuse him a work permit, chances are he won't have enough resources, therefore they'll have to leave. If you don't give him the right to stay, also there's nobody to look after them, they have to leave.
Exactly.
And that emerges very clearly from paragraphs 42, 44 of the judgment.
Your Ladyship has exactly the points I was about to make. You've certainly making them. That's right. The notable and really the controversy around Zambrano arises because it begins where free movement ends. And that's why it's so was at least at the time so controversial for a number of member states, not least the United Kingdom. Because, of course, paragraph 39 begins by saying you fall outside the scope of the Free Movement Directive. So you're not a beneficiary. So on the face of it, certainly for an English lawyer, that's quite a startling proposition that you can then still have rights, because you don't have rights under the key provisions of free movement law that the treaties and the directive are supposed to enshrine. But what Zambrano does is, as my lady put it to me in opening, is fill that gap, because there are, of course, children, and a number of the derivative rights provisions deal with children. Chen is about children. Teixeira and Abraham is about children in education. They deal with the fact that EU minor citizens, or perhaps vulnerable adults as well, as we see from the Patel and Shah decision, are in a position where they cannot enjoy those rights in EU law, those fundamental rights as EU citizens, EU citizenship, of course, having been added to the treaties throughout their life and development, without the assistance of carers. And those carers may be third country nationals who otherwise have no right to be here. So that's exactly the point.
Well, it's really the last line of para 45 really sums it up. You can't refuse the various rights insofar as such decisions deprive those children of the genuine enjoyment and substance of the rights attaching to the status of European citizens.
And one might think the words insofar as are quite important there. What one sees then from the development of the cases, as I've said, and I'll go into these cases right now, is compulsion is the critical criterion. Because if you're not compelled to leave, you don't need any assistance to stay. There's a grant of a right of residence or a grant of a right to work, for example. But also, critically, one sees, particularly in domestic cases, that this is a highly fact-sensitive analysis. That's why the words insofar as have real meaning. So in Patel and Shah, you see different decisions in each of the cases based on a very fact-sensitive reading of the findings that have been made by the tribunals in that case. I'll come to that in a moment. But that's absolutely right, my lady.
You're eliding right of residence or right to be here and right to work, as though they're obviously covered by the same principles. I think the Vice President has flagged this up earlier.
Yes.
I'm going to come back to it.
Well, that's an entirely fair point, put to me, if I might say so. Yes, I have elided them. I've elided them because, in a sense, in the court's analysis, they come to much the same thing. What the court is saying is these are the rights that you, the member states, may need to grant to individual third country nationals, non-EEA citizens, who have children who are nationals of the member states who haven't exercised free movement. And as my Lord absolutely rightly puts to me, it's not just residence. Yes, it's work as well. So in a sense, what I've said about residence goes for work too, because if you didn't have the right to work, then in substance, you might effectively be compelled to leave because you wouldn't have any recourse to funds to enable you to stay. That's the logic of that position. It comes back, the right to work, in a very real sense, to a right of residence as well, but it's to avoid effectively constructive compulsion to move. So what you can't do is you can't put somebody in a position where they have to leave. That's why you have to have the right to work. The corollary, of course, are the benefits cases like SANA and HC, which demonstrate what you don't need to do is give a right to benefits. You've got the right to work. That's your remedy in EU law.
Yes, but if somebody here under discretionary leave to remain doesn't have the right to work, they may, if they ask very nicely and the Home Office decision maker agrees, be allowed to work. But that's not, I wouldn't describe that as a right to work.
Well, they certainly have a right to ask the Home Office to remove any condition which prevents them from working. So the starting point would be an ability to work removed by condition. Now, the circumstances are going to be very important. So, for example, one of the situations, discretionary leaves, I'm sure the court will realise, used to be granted very, very commonly. You used to have discretionary leave, exceptional leave, and then classic indefinite leave or limited leave. And terminology has varied over time. Discretionary leave now is, just to take one example, very often granted on a rolling 6-month basis to people who, for example, would be returned to a third country were it not for an Article 3 risk of breach abroad. And there the impositions of, frankly, quite harsh conditions for their continued residence serve an important policy aim. So the circumstances in which a right to work is removed by condition are highly important, and that's why I've slightly soft-pedalled and paused on that point in response to my Lord's question earlier on. And I do want to take instructions on that because I absolutely see the point, but it seems to me at the moment that the factual circumstances in which, for example, that condition is imposed on discretionary leave are quite important from a policy perspective.
No, but to me, so to be clear about this, I'm sure this is right, but correct me if I've got it wrong. Nowhere in the rules gives anyone with anything short of ILR a right to work. In the case of every form of leave to remain, other than unlimited leave to remain, the right to work is the subject of conditions.
Yes, it would be. You would have a condition which would remove any right to work. It would
Yes,
make
I
it-
see. So in fact, the boot is on the other foot.
Yes. That's why I
On the
said,
print, yes, no, I'm sorry. Well, you're right, you did correct me. On the principle that anything that's not forbidden is allowed, if you are given leave to remain and no condition is imposed about the right to work, you have the right to work.
correct.
But if that's right, so conceptually, the status of a so-called work permit or an endorsement on your conditions that you have the right to work is merely to make the position clear to employers. It's not actually the essence. Is that right?
Well, it would, in reality, under the system as it operates at the moment, and again, it is obviously rather complex. There are specific categories according to which, under the points-based system, you can enter with rights to do certain things which are effectively limited in advance. But if one has just, for example, if one simply had limited leave granted at large without a condition in relation to work, then one would be able to work. But if, on the other hand, one had a limited leave which said, you shall not work.
So what we call loosely a work permit is, strictly speaking, it's the opposite. It's the statement of conditions
Yes.
limiting what would otherwise be an unlimited right to work. It may, for a student, say only 16 hours a week or whatever it is.
Yes.
But conceptually, there's no ban on anyone working unless that is made a condition.
You'd have to have a condition which said, you may not work.
Yes.
But that's the norm, isn't it?
Can I take instructions on that? Because that does depend on policy, and the policy changes. And its position has changed fundamentally in the last 15 to 20 years. My Lord refers to work permits, and that was the system. But now there's a points-based system, which is much more complicated and much more specific. You have the different tiers.
Yes, but the bottom line has always got to be that an employer is not going to employ you without seeing a bit of paper from the Home Office that says you can work.
Yes.
But conceptually, that is evidential. If you just turned up in front of the employer and said, "Look, here, I have leave to enter, and there is no condition saying I can't work, so I can," the employer will be puzzled and say, "No, I want to see something saying you can." Is that not the reality?
My Lord, I think in practice there are cases where evidencing these things can be difficult. For example, as I understand it, there are hotlines for employers that they can call to confirm people's work status. There are systems that are available to enable them to do that precisely because of that sort of risk. I know that from other litigation which I've been involved in for the Home Office. But again, the situation is slightly complicated.
I know it's very complicated,
Yes.
and I really don't. It's not important we get into this. It's set to understand the concept.
Yes, I understand.
And have I got this right? In principle, and I emphasise in principle, anyone with leave to remain has the right to work unless there is a condition that they can't or can only do so subject to certain terms.
I got nods from behind me when your Lordship summarised the position in that way, so the answer is yes. And my learned junior has again just shown me an online tool that can be used for work checking as well.
No, they can be like. I'm very familiar with the fact that exists, but
Yes.
I also know that as soon as you get into the weeds, it's very, very complicated, and I don't really want to go there. I just want to understand the overall theoretical position.
The way my Lord's put it as a broad conceptual position is correct.
Perhaps we can say one more thing, which I think is the point of my Lord's question. Again, at a high level, despite that being the theoretical position, the reality is that I'm trying to put it accurately. The reality is the Secretary of State will want to see a positive reason why you should have the right to work. In other words, the default is he or she will impose a condition preventing the right to work, unless you fall into one of as you say, an enormously complicated variety of categories in which you do have the right to work.
Given your Lordship's use of the phrase by default, may I check that by instructions and come back to your lordship. I see why your lordship puts it like that, but I just want to check that I give the right answer to the court.
Yes.
Because of the complexity of the weeds that my lord referred to.
All right. Well, this may not matter at the end of the day, but I think it's still been a helpful discussion to have.
But that's in a sense the risk I'm concerned about. It doesn't matter in this case. It may matter if the court says something for other cases. And I certainly don't want to be counsel for the Secretary of State who leads to that scenario.
Well, I suppose, I mean, the reason why it is perhaps important is one of the things we're going to have to consider here about what exactly conceptually is a Zambrano right to reside, and or this the other element, the Zambrano right to work.
Yes. Well, what I can say, my lord, is this.
And how does it interrelate with the domestic right to work? That's why we are in this area at all.
So in my submission, the answer to that question is a Zambrano right, and I'll just say Zambrano right at the moment. The Zambrano right consists of two parts, a right to reside and a right to work. Now the separate question then, which arises in this case, is when that right is triggered and whether it is defeated by the pre-existence of a domestic law right of residence. So conceptually, for the analysis in my submission, that's how the case plays. And I use then the phrase not defeated by. It might be more accurate to say does not arise as a result of a domestic right of residence. The court has, I hope, my positions on Zambrano itself and the centrality of what it is Zambrano is trying to protect and its derivative, fundamentally derivative nature. I next move to the second of the sets of cases, which is Chavez-Vilches and KA. Chavez-Vilches, the court will find behind tab 10. There are a huge number of cases that went before the court in Chavez-Vilches. Chavez-Vilches was just one of them. I don't need to go through, the court will be relieved to hear any of the facts. In summary, they all involved a variety of factual scenarios involving basically single mothers in the Netherlands with primary care of children who had varying degrees of contact with their birth fathers, and the mothers were non-EEA citizens. So that's how the Zambrano issue arose. And the real issue was where there is some potential, possibly for a parent, another parent, the EU citizen parent, to care for the child. How does that affect the way Zambrano arises? I don't need to go through the facts in any more detail than that. Can I ask the court just to turn to paragraph 63 of the it's a Grand Chamber decision, Grand Chamber's judgment. So page 334 of the bundle. Perhaps I can ask the court to read paragraph 63 and then 65.
Yes.
And you'll see in 63 the wording on which I alight, about halfway through, if as a consequence of refusal of such a right, that citizen would be obliged in practice to leave the territory of the EU as a whole. So obligation in practice. That captures both the notion of compulsion, and the language of compelled is used in paragraph 65, and also compelled in practice in my submission captures in part this idea that you may need the right to work as well. It may not just be that you're actually required to move because you don't have a right of residence, but also because there are practical issues which prevent you staying. And as I say, in paragraph 65, you see the introduction of the language of compulsion. Again, halfway through, those children might be compelled to accompany their mothers and therefore to leave the territory of the EU as a whole. In the event that the mothers were obliged to leave the territory of the EU, the children would thus be deprived of the genuine enjoyment of the substance of the rights conferred. And similarly, at paragraph 70, again for the court to note, you see the introduction of the language of compulsion again. Don't need to trouble the court with more of that. And there's a similar finding in the dispositive on page 337 over to 338. So we say critical, what becomes clear at this stage, if it wasn't clear before, is that the critical issue is compulsion to leave. And whether that test is satisfied, as the remainder of the judgment demonstrates, depends on a clear and exacting analysis of the relevant factual scenario.
Well, it's really testing the level of dependency on the non-EU national parent, isn't it?
Exactly.
Because it's not enough to say, oh, well, Dad's in the jurisdiction and therefore could look after little Jimmy.
No.
It's to what extent is there such a dependence, emotional or otherwise, on mum, that the child would, in practice, be likely to be compelled to leave.
Exactly, because one can imagine a situation in which a member state would be tempted in response to Zambrano to have a position in law which basically said, well, if your EU citizen parent is here, goodbye.
Yeah.
But that's not what member states can do in the light of Chavez-Vilches and the cases which follow.
That was all that was decided in Chavez-Vilches, is it's not good enough to simply say, well, there's a EU citizen parent present and that parent could potentially look after the child.
That's right. But one does see the introduction, as I say, of the language of compulsion here.
Yeah.
And that becomes developed in the cases. And if there's any less of any doubt about that, one sees that then picked up in the next case in the bundle, which is KA. That's another decision of the Grand Chamber from May 2018. And just to summarise the facts, at the top of page 340, I'll just read the first few lines. You'll see that the applicants in the main proceeding were third country nationals, family members of Belgian citizens who did not exercise the right of free movement or establishment. Return decisions had been issued in respect of each of them, accompanied by entry bans, which become final. And under national law, those entry bans could not be extinguished or suspended unless applications were lodged outside Belgium for their withdrawal or suspension. The applicants lodged, therefore, applications for residence permits based on family reunification as dependent relatives in the descending line or parents of minor Belgian citizens, and so on and so forth. So that's how the Zambrano issues arose there. There are a variety of issues which dealt with by the Grand Chamber in the judgments. The relevant provisions I want to take the court to are, first of all, paragraph 51 of the court's judgments. And the court will see that as is often the case with CJE decisions, you see the same wording repeated once a test is established. So I'm not going to, hopefully, not going to belabor the point, but you will again see 5 lines up from the bottom of 51. If there's a consequence of refusal, right, the citizen would be obliged in practice to leave the territory of the EU as a whole. And then 58. Can I ask the court to read 58, which is an important paragraph?
So this is, it's a bit like Chikwamba, isn't it? It's again, it's applying the same principles in this rather narrow situation where you have to leave and to apply to get back in.
Exactly.
And the child may have to come with you. And that's the significance of the phrase for an indefinite period. The implication we don't need to decide this is that suppose it had been assured that as long as you go back to wherever the country is, the Belgian embassy will process your application in a fortnight and you'll be back in Brussels in 3 weeks' time. That might have been okay.
Yeah.
But the point is you go off to, I don't know which country it was, I can't remember, Congo, say, and you just don't know when, although in theory, if you have the right, they will come back, you don't know for how long. And that's what's said to be unacceptable. Have I got that right?
That's broadly right.
So I'm slightly puzzled by this phrase for an indefinite period, which then gets into the jurisprudence, but that's the force of it.
That's the force of it. With Chikwamba, of course, what you have is a policy issue around queue jumping. And we all know what the
the legal issues are different, but I mean, I was just using it as a shorthand for the factual situation.
Yes, yeah. The issue here, and this is why it refers to the objective pursued by Article 20 being defeated, is because, of course, whatever period that the individual was outside, and if it's for an indefinite period, then it's going to be a long time for the children, they are unable to enjoy the benefit of their rights as EU citizens.
Right.
And of course,
I don't think but I think I'm right, aren't I? That the implication is that if there was some reliable assurance that it was for a short and finite period, it might not offend the underlying principles.
Well, it might not. The only difficulty with that might be that, of course, in terms of, well, it would, if it involved constructive removal of an EU citizen from the territory of the EU, one can imagine that might give rise to quite sensitive concerns even for a short period of time. So that's, I would just sound that note of caution. I see why my Lord makes the point given the reference to for an indefinite period. And that does resonate in a particular way with Chikwamba and other issues as well. But there would be other problems, even if it was for a short period. The point is, if you have a right under Article 20 as an EU citizen to enjoy your rights as such, then if that's going to be defeated, even for potentially short period, potentially there are going to be problems.
Maybe, I don't know. I don't quite know why they said for an indefinite period otherwise. No. I'm sure they were concerned. I'm sure if we went back to the facts, they were concerned that you'd have to go back to whichever country. Which country was it actually? Guinea. Well, they're from various.
There are a number of countries. But of course, the removal decisions, or the return decisions as they were called, in Belgium were accompanied by entry bans.
Yes, you couldn't come back in.
Yes,
exactly.
but
that may be what's triggered the
No, but that's only a part of the thing. The effect of the entry ban is that you have to apply for what we would call leave to enter from abroad.
Yes.
And presumably the argument of the Belgian government was, well, they just go away, and then if you're right that there is a Zambrano right, they can come back again.
Yes.
And the court is saying, no, that's not good enough.
Yes. My Lord, it's absolutely right that the court has said what it said in paragraph 58 by reference to departure for a potentially indefinite period of time. But it does seem to me there would be issues in EU law potentially for a shorter period, even if it was a relatively short period of time. If it was a day or two, then perhaps not.
Well, let's not go there unless we have to. I just wanted to pin down what the origin of that phrase was and what was the thinking behind that phrase.
Well, in terms of the reference to indefinite period, my submission would be that likely comes from the existence of the entry bans and the potential effect of the entry bans. It's the facts of the case. I don't think the court is meaning to include any wider statement of principle with that particular wording. What is significant in my submission is the fact that it says the objective of Article 20 would be defeated.
Well, perhaps one of the juniors could just, perhaps one on each side, well, there is only one on each side, the juniors could just over, while you're talking or over the short German, just look back into the analysis of the facts to see if the phrase for an indefinite period, which I suspect it does, comes out. Well, some phrase like if you send back to Armenia or wherever it is, you may be there for an indefinite period until the decision is taken.
Well, I'll come back to you on that, absolutely.
Yeah, thank you.
So that's paragraph 58. The only two other paragraphs I'm going to refer the court to, but it may be the court can read this in its own time, as it were. 71.
Already got that marked.
Great, my lady. 74, you beat me to it. So 74 is a repetition of the direct sheet principle. that again the court will be familiar with. It's not enough simply it's desirable.
Desirability isn't good enough. You've got to
Desirability.
show there's a real risk of compulsion.
Exactly. And again, that's an issue which got litigated to the Supreme Court in previous cases. So the point I take from those two cases is that compulsion is the critical criterion. My lords, my lady, that brings me to the third and final stage of the ECJ case, or CJU case, and the two decisions A and IDA. Again, to give you the submission at the outset, submission is that it's clear that where the putative Zambrano beneficiary benefits from an alternative right of residence, the Zambrano right does not arise. That's obviously important for this case. Can I begin with A, or NA as it's sometimes referred to? You'll find that behind tab 9. The facts, such as their relevance, are summarised in the head note. In summary, A was a Pakistani national who'd married a German citizen and moved with them to the United Kingdom. They had children born in the UK who had German nationality. They divorced because of domestic violence, but the divorce wasn't final until the German national, who was the husband, left the United Kingdom. There was no retained right of residence under the Citizens Directive. Significantly, the children were in education in the United Kingdom. On appeal, the tribunal in this jurisdiction found that they therefore benefited from a right of residence under Article 12 of Old Regulation 1612-68. The tribunal also found there were rights of residence under Articles 20 and 21 TFEU. That led to appeals and cross-appeals to the Court of Appeal and a reference from this court to the Luxembourg court. I say all of that is summarised in the head note. So the Zambrano argument is considered in the judgment at paragraph 69 and onwards under the heading the second and third questions. And you'll see at 69 that the referring court is seeking to ascertain whether Articles 20 and 21 confer a right of residence on a minor union citizen who's resided since birth in a member state, so the Zambrano situation, but is not a, who's resided since birth in a member state, but is not a national of that member state, and on the parent, so not a Zambrano situation, the parent, third country national who's sole custody of that minor, where the persons concerned qualify for a right of residence in that member state under national or international law. There's then reference to the standard case law in Article 20, Gazalchik, and so on. And then 71 over the page. On that basis, the court has previously held that Article 20 precludes national measures which have the effect of depriving union citizens of the genuine substantive rights. See Zambrano, so the classic Zambrano statement. And then there's analysis of Direcci at 72. I don't need to go through that. 73, as regards the situation such that at issue in the main proceedings, account must first be taken of the fact that both the applicant and her daughters qualify for a right of residence in the UK under Article 12 of the regulation. The first condition on which the possibility of claiming a right of residence in the host member state under Article 20, as interpreted in Zambrano, depends, namely that the person concerned does not qualify for a right of residence in the member state under EU secondary law, in this case is not met. So here, what you have is the existence of another EU right of residence, defeating a potential Zambrano right.
What is the right of residence under Article 12 of regulation, whatever?
So I can just go back. We have Article 12 in here. So Regulation 1612-68 begins at page 281 of the bundle, and you'll see Article 12, paragraph 10 at the bottom of that page. Children of a national member state who is or have been employed in the territory of another member state shall be admitted to the state's general educational, apprenticeship and vocational training courses under the same conditions as the nationals of that state if such children are residing in its territory. So it's a right which attaches to the engagement in education and training. And yes, I can hear whispering, I think, from Mr. Cox also. Paragraph 65, he rightly refers to the Baumbas decision, which deals with the right of residence that arises from Article 12. So just above there, 65, in circumstances such as those in the main proceedings, where there's a right to continue in education.
So sorry, I was just making a note on something else. Where are we?
65, paragraph 65 at page 289. And that's a summary of the principle in Baumbas.
So Dad is the EU citizen. Dad leaves the UK
Yes.
and divorce gets underway. But by this time the children are at school.
Exactly.
And so they have an Article 12 right to continue throughout their education.
And the mother has a derivative right.
At British schools, and the mother has a derivative right from them, so she doesn't need
Exactly.
any other derivative right.
That's right. That's exactly the point.
But just conceptually then, but it's still a derivative right, but it's treated as a different animal from the Zambrano right.
Yes.
And the one, conceptually they're both the same kind of animal, aren't they? One is to enjoy the dependent, to allow the dependent to enjoy their EU right of residence. And the other is to allow the dependent their EU right to an education in the country of which they're not nationals.
So that's right. The Baumbas right, the Baumbas derivative right, is enabling the children to continue to enjoy their right to be engaged in education and training. Whereas a Zambrano right, you don't have to have engagement in education and training or anything of that nature. It's a right which derives simpliciter from the citizenship status. So that's
Does it make any difference in principle? One derives from citizenship status, one derives from a particular right under Article 12.
Well, for my purposes, my lord, no. Because the point that I'm able to take from A is that the court recognises, and this is why we refer to occasion as a right of last resort, if there's an alternative right in existence on which the individual can rely, Zambrano doesn't arise. And in a sense, this comes back to the point put to me by my lady. Zambrano fills the gap. There's no gap to fill here.
Not if the children are attending school.
Sorry, when I say here, I mean in this scenario.
If
yes.
the relevant child or children were babies or toddlers not yet at school,
Correct.
then there would be no Article 12 right. So mum would need Zambrano.
Yes.
And that's
Exactly.
where it would have arisen the interesting question of whether you get a Zambrano right if they're actual nationals of a different EU state rather than the one in which they are residing.
So if it was a national...
A bit later on in the same judgment.
Yes, and a national of a different member state, you would probably be in Chen territory then. Chen, of course, predated Zambrano, was an important stepping stone on the way. One of the Zambrano cases, which is referred to in the skeletons but is not before the court, is Rendon Marin. And there you had an individual who had children with two nationalities, both EU nationalities, but different EU states within one state. And one of them, it was in Spain. One child was Spanish, one child was Polish, because of the way the family had moved at the time when the children were giving birth. And one scenario with the Polish child resident in Spain gave rise to a Chen right, and the scenario with the Spanish child resident in Spain gave rise to a Zambrano right. Now, we haven't troubled the court with that. It seemed excessive because we can get the points from elsewhere, but one sees that these cases can be a little bit like EU law examination questions in terms of how the different nationalities stack up and what that means then in terms of the accumulation of derivative rights. But once you've got another right of residence in EU law, you don't need Zambrano. As I say, it comes back to the point about filling a gap.
And why is it that way round? Why can't you say, as long as you have a Zambrano right, you don't need a Chen right?
Well, ultimately...
Or a Baumbas right?
Yes. because you're starting at looking at what derives from the secondary legislation. In my submission, that would be the analytically correct way of looking at it. So with, for example, somebody who's got the bound-bast Article 12 derivative, right, it derives from secondary legislation, you'll recall the starting point for Zambrano is that you're outside the scope of the secondary legislation. In that case, it was the Free Movement Directive, the Citizens Directive. But that's why it comes in that order. It's because, and again, it's because Zambrano is in a sense so residual. It exists, it's both, I can put it this way, it exists at the periphery of EU law because it starts where free movement ends, but in a sense, it also exists at the heart of EU law because it gives effect, true effect in practice, to citizenship rights. So it's peripheral and central at the same time, but in different ways.
And that's certainly the way that the CJEU's looked at it.
Yes, my lady, absolutely. It recognises it's exceptional and, as I say, not engaging free movement. And that reflects the history of the development of citizenship in EU law, EU citizenship in EU law. It's moved to become, as the cases say, the fundamental status within the Union. Zambrano is very much both a creature and a marker of its time. It's Chen and all those cases. If one starts with the early derivative rights cases like Surinder Singh, and then moving on through to Kshiri Ibrahim, Chen incredibly controversial. Zambrano would have been almost inconceivable at the start of that process, but by the end it's the natural conclusion, even if it certainly didn't feel like that in 2011. Whenever it was. Now, I do no more than headline the point here, but you will have seen that was a submission, or reliance on A was placed by the Secretary of State before Mr. Justice Mostyn, and he distinguished it in part because it was dealing with a right under EU law, and he said, well, it's not the same for domestic law right. We say, impossible to see why that should in principle be the same. If there is a gap to be filled, there's a gap to be filled. But the next case I'm going to take the court to actually assists on that point, and that's the case of Ida. That is at tab 7 of the bundle. And again, the facts are summarised in paragraph H3 of the headnote, but in shorter summary, they are this. Ida was a Japanese national who married a German woman in the United States. They moved to Germany. The daughter had Japanese, German, and US nationalities. The German wife then moves to Austria to work, and they separate. I did say these cases were a bit like exam questions on EU law. The daughter is effectively has split custody arrangements between them. So Ida remains in Germany, his daughter visits him, and he visits her in Austria. He lost his autonomous basis for German residence through marriage because of the separation. The marriage had lasted less than 2 years. But he was granted an employment-based residence permit for a limited duration. Those are the basic facts. Consideration of the Article 20 and Zambrano issues is at paragraph 66 and onwards. And you will see interpretation of Articles 20 and 21. It's at the top of page 218 of the bundle. And there is a discussion in these passages from 66 onwards of the treaty provisions and the derivative rights which arise. And you will see at paragraph 71 the reference to very specific situations and the reference to Diretci. And that is effectively the Zambrano scenario, 71. You'll see then 72, the common element in the above situations is that although they're governed by legislation which falls a priori within the competence of the member states, and legislation on the right of entry and stay of third country nationals outside the scope of those directives, 2004-38 Citizenship Directive, they nonetheless have an intrinsic connection with the freedom of movement of a union citizen, which prevents the right of entry and residence from being refused to those nationals in member state of residence in order not to interfere with that freedom. Can I then ask the court to read 73 through to 77, please?
Yes.
So, my lord, what the court does in those passages is to list a series of objections to a right of residence arising under Article 20. It starts with the fact that the spouse and daughter are in a different country, but it then makes three, in my submission, really significant, critical findings. So finding number 1, paragraph 74, Mr. Ryder has always resided in accordance with national law. I emphasise national law, not, like in A, an alternative EU right of residence. Finding 2, also in 74, the absence of an EU right of residence has not discouraged, in fact, his spouse and daughter from exercising free movement. Zambrano is a very practical right. It's not a theoretical one. Finding 3, paragraph 75. He has, Mr. Ryder, a right of residence under national law which is renewable and can lead to the status of long-term residence. Well, that sounds, in my submission, very like the nature of Appendix FM leave in this case, which, as here, is granted on a 10-year track to indefinitely. I'd note at that stage, I asked the court to compare paragraph 24 of Mr. Justice Mostyn's decision, where he said the court in the Zambrano jurisprudence didn't have in mind limited rights to remain and work under national law. I said that's impossible to reconcile with those passages. Where does that trio of important findings lead? It leads to the conclusions of paragraphs 76 and 77. And the court concludes, first, it cannot be validly argued that the decision refusing a right under the treaty would be liable to deny the EU citizens the genuine enjoyment of the substance of their rights, or be such as to impede freedom to move. That was impossible to argue in that case. And secondly, a purely hypothetical prospect of exercising the right of freedom of movement, or of the right being obstructed, is insufficient to engage EU law. That's paragraph 77. That's very important. EU law wouldn't be engaged by hypothetical obstruction. Now, in my submission, both those conclusions at paragraph 76 and 77 are very important, and I say ultimately fatal to Ms. Akinsanya's case. If you have a domestic law right to reside, it cannot be validly argued that your genuine enjoyment of the substance of your rights as an EU citizen, which is the basis for a Zambrano right, is in any way imperilled. Nor can it be said there's any threat to free movement other than a totally hypothetical one. So IDA does take the matter further than NA because it deals with the existence of rights of residence arising under member state domestic law.
Hang on a second. Yep.
The difference, of course, is that it's a right of residence in a different member state from the one in which the child is.
Yes, but Miley, that's right. But of course, the point made by the court in these passages is that the existence of the right of residence, and of course, the child was visiting in Germany as well.
It was said that didn't really impede her rights.
It didn't impede her, exactly. She'd exercised free movement, notwithstanding the father couldn't move with her. What it, in a sense, boils down to is, again, that the protection offered by Zambrano to give effect to Article 20 is practical protection. It's not a theoretical protection. And if, notwithstanding the refusal of a Zambrano right, you wouldn't have to leave, you wouldn't be compelled to leave. There's no need, there's no gap to be filled. We're going to come back to the language of gap filling. Now, I would have made that submission on the basis of A in any event and said it flows because there can be no distinction in principle. But I do say IDA puts the point beyond any reasonable argument. My lords, my lady, that's what I want to say about the ECJ, CJU cases. There's just one case you'd be relieved to hear domestically that I was proposing to go to as a decision of the Supreme Court. I think it would be remiss of me not to go there. It's Patel and Shah. And it wasn't the first time the Supreme Court had mentioned Zambrano, but it was the first time it had looked at it in any real detail. There were one or two references in, I think in Pham and in one or two other cases as well, but this is the first substantive examination. It is behind tab 18. And you will see the first entry behind tab 18 is the Court of Appeal's decision. Just as we are here, you will see in page 620, there is a paragraph 68, in the judgment of Lord Justice Irwin, who gave the sole reasoned judgment in the Court of Appeal. Lady Justice Thirlwell and Lord Justice Lindblom agreed with him. At paragraph 68, he records a submission from me. In Patel's case, the claimant had already failed in an Article 8 claim. Had he succeeded, the result would have been a grant of leave to reign, which would obviate the need for leave under the Zambrano principle. Now, I think it's said against me that in certain passages in the Secretary of State's guidance, that is in effect treated as a finding of the court. It is entirely fair, a point to put against me that is not quite right. It is a submission I made and is recorded as such as a submission. It's, I think, fair to say equally that the court doesn't say that's wrong, but there is no positive finding to that effect. But you can see that was a submission being made, consistently with the submission being made today. The Supreme Court decision then begins at page 624 for the court's note. There were two cases. The first case, Mr. Patel's case, involved an adult child who was the carer for his seriously ill parents. Mr. Patel's father had an end-stage kidney disease. He was very ill. And again, it is fair to say Mr. Patel provided very, very significant care for his father and for his mother as well. His parents were British citizens, he was not. So that's how the Zambrano situation arose. The Shah is perhaps the more classic Zambrano case where you have two parents. The father is not an EEA national, the mother is a British citizen, and the child is British. But the father, a non-EEA citizen, was the primary carer. Those are the facts. The passages I want to take the court to, first of all, paragraph 22. I should say the overarching submission being made on behalf of the appellants was that Chavez-Vilches, which you've seen, had introduced a sea change to the Zambrano jurisprudence. Now that submission was rejected. It was made clear, Chavez-Vilches set out how you examine the facts very carefully, particularly in the position of children, with all the rights that arise, therefore, under Article 7 of the Charter, Article 8 of the Convention. But that overarching submission was not accepted. But although Mr. Patel's appeal failed on its facts, Mr. Shah's succeeded. 22, page 634, what lies at the heart of the Zambrano jurisprudence, I should say this is Lady Arden, who again gave the judgment of the court. What lies at the heart of the jurisprudence is the requirement that the Union citizen would be compelled to leave Union territory if the third country national with whom the citizen has a relationship of dependency is removed. There's a reference to, I'll call that the case of O. It's the role of the national court.
Very cowardly of you, Mr. Mann.
Yes, my finish is not up to it these days. As the CJU held in the case of O, it is the role of the national court to determine whether the removal of the third country national carer would actually cause the Union citizen to leave the Union. In this case, the FTT found against Mr. Patel and concluded that his father would not accompany him to India. That means that unless Chavez-Vilches adopts a different approach to compulsion, Mr. Patel's appeal must fail. No question of his being able to establish any interference with his convention right to respect for his private or family life, as he's already failed in that regard. And that is a reference, in a sense, to the point I was making in paragraph 68 about there had been an earlier Article 8 application. The next paragraph I'm going to take the court to is paragraph 30. And to make paragraph 30 make sense, could the court read paragraph 29 first of all? It's the submission I was making. you'll see that slightly, perhaps it might be thought opportunistically, I'd sought to rely on the directory statement about desirability, choice, economics, those kind of factors. And Lady Arden at paragraph 30 said, I don't accept that submission. The overarching question is whether the son would be compelled to leave by reason of his relationship of dependency with his father. In answering the question, the court's required to take into account in the best interests and specific circumstances those factors as a reference to Cheller's Vilches. Then the test of compulsion, is thus a practical test to be applied to the actual fact and not to a theoretical set of facts. As explained in paragraph 28 of this judgment, on the FTT's findings, the son would be compelled to live with his father, who was his primary carer, though that was sufficient compulsion for the purposes of the Zambrano test. There's an obvious difference between this situation of compulsion and the impermissible reliance on the right to respect for family life and desirability, or keeping the family together as a ground for obtaining a derivative residence card. The Court of Appeal was wrong to bring this into issue. So we were stuck effectively with the findings, entirely fairly, of the FTT on the evidence, which had not been challenged through cross-examination by the Home Office presenting officer. So again, shows the criticality of the facts. What you have to apply the test of compulsion to are the actual facts and not theoretical facts. Now, I say that is strong support for our submission, that if the actual facts include, as they must, the fact that there is in existence a domestic law right of residence, there can be no compulsion.
And a domestic law right to work.
Yes, I accept that. Now, my lords, my lady, that's what I was proposing to say about Shah and Patel. Before I move to Mr. Justice Mostyn's judgment on ground one, can I just make 2 points about submissions that were made on behalf of my learned friend, and obviously he'll make a development in the way in which he wishes now, but I headline them now so he's got my response in summary. First of all, he suggests that we're wrong to say the focus, as I understand it, he says we're wrong to say the focus is on compulsion vis-a-vis both the third country national and the child. Well, we struggle to understand that. The position of the child is obviously intimately linked with the third country national, as indeed Patel and Shah shows, as also KA shows. You can't divorce one from the other. You have to look at what the compulsion on the adult to move does to the child's enjoyment of citizenship rights. Secondly, he makes a point at paragraph 18 of his skeleton about where he effectively says we are in some way relying on SANA for a conceptually misconceived argument that Zambrano ceases to exist as soon as it is met. Now, again, I'll wait and hear how he deals with that in his submissions and perhaps respond in reply if necessary, but we don't really understand that, and that's why I'm flagging it now. We're not relying on SANA here. SANA is a case all about the point in time at which Zambrano arises. It involved what might be thought a bold and difficult submission on behalf of the different secretaries of state, that effectively Zambrano rights only arose at the door of the aeroplane as somebody was being removed. Well, it doesn't take much imagination to imagine why that didn't go down very well in this court. That truly would be overly narrow analysis of anything the Court of Justice has ever said, particularly given my Lord's point about the need for a right to work as well. But I don't say any more about that at this stage, just to indicate that we don't accept that characterisation, obviously. My Lords, my Lady, may I move then against that background briefly to look at Mr. Justice Mostyn's decision? You will have that.
Yeah, that's fine. I mean, you're doing well, and not sitting for a moment. You've been slow. But can we just have a
yes,
rough picture? Are you still on course to finish by lunchtime?
Yes, my Lord.
Round two is probably shorter.
It is shorter, exactly. And
that's
round
fine.
two,
I say no more about it. If
No.
you were going to go much into the afternoon, we begin to get a bit itchy.
I understand.
The person going first inevitably takes longer because you've
Yes.
got to introduce us to the cases. Okay, that's fine.
I'm grateful. And I promised Mr. Cox that I'd finish by lunchtime, so I will do. Ground two, I will largely take by reference to my skeleton, so that will take things more quickly.
Okay.
So, Mr. Justice Mostyn's decision, judgment is in tab 6 of the core bundle. Well, sorry, not tab 6 of the core bundle. It is in the core bundle.
48.
Very grateful, my lady. 48. Begins with the usual preliminaries. I can skip over all of that. Facts at paragraphs 4 to 12. And then, under the heading, the scope of the Zambrano jurisprudence, that's page 38. Sorry. I think my lady said 48. So,
By paragraphs.
51. Yes. Paragraph 13. Paragraph 13, one sees the scope of the Zambrano jurisprudence. From here through to paragraph 54, the judge deals with what is now ground 1. And there are 4 key features of his reasoning which I need to take the court to.
Sorry, where are we going?
Paragraph 13, my lord.
Yep, okay.
And the 4 key features, just so the court has them. The first one is a finding he makes in relation to Mr. Zambrano's rights on the facts of that case. And that's in paragraphs 17 to 20. The second is what he describes as the long-term nature of the Zambrano rights. We've given the references in our skeleton at paragraph 33. They're dotted throughout the judgment. Thirdly, the distinction between the EU right of residence and domestic rights of residence for Zambrano at paragraphs 30 to 35. And then fourthly, what he says
Hang
about...
on 1 second.
I'm sorry.
Yep.
And then fourth point is his reasoning in response to the point that the only relevant factor is compulsion. That's paragraph 36. So you'll see he deals, going to the first of those, the facts of Zambrano. This is why I went through that in a little detail earlier on. At paragraph 17 to 20, he describes the position in terms of Mr. Zambrano's residence permits. He says that on 30th of April 2009, Zambrano was given a provisional renewable residence permit and a work permit, valid for 1 year and renewable. He makes some reference to that into the judgment. Then he sets out at paragraph 20 an extract from the Secretary of State's skeleton argument, where it said there was no question as to the effect of refusing the right of residence to both parents, both third country nationals with no other lawful basis to stay, children obliged to accompany them. In other words, it's been a fundamental condition for the application of Zambrano from its inception that there be compulsion, and in practice the jurisprudence has imposed a high threshold. He says, I don't think that's correct. As I've explained above, the family could not be deported because of non-refoulement order, and Mr. Zambrano holding a limited renewable residence permit being entitled to a limited work permit. So there's no question of them being compelled to leave if they were not granted this novel right. And he makes an observation about the non-refoulement order. But of course, as I demonstrated before, the critical issue for the court was the status in terms of lack of residence permits at an earlier stage when Mr. Zambrano was claiming unemployment benefits and being refused unemployment benefits precisely because he had no residence compatible with the Belgian law on the residence of foreign nationals.
In fact, Zambrano, although they had to go via right of residence to get there, is entirely a right to work case. Is that right? Because he had, I don't understand Belgian law,
no,
but the effect of the non-refoulement order was that he had a right to reside.
No, I don't think it was, my lord. The effect of non-refoulement order was that he couldn't be returned.
He couldn't be
No,
returned.
but what's the difference? What's the difference?
Well, my lord, as I understand it, the difference is that he couldn't be returned, but he didn't have a right to reside.
But what's the difference? If you can't be returned, you have a right to reside.
Because if you don't have a right to reside, my lord, then you can't work lawfully in Belgium.
Well, that's my point.
Right, but it stems from the lack of a right of residence.
Well, I'm not sure it does. The issue in Zambrano is entirely about benefits which depended on a right to work.
Yes.
This was not. His removal was never in question. I'm not sure this defeats your answer to Justice Mostyn's point.
No.
But I don't quite understand. I don't think, if only because of how EU law works, the CJEU can't have been intending to create. Can't be intending to pick and choose between different kinds of national ways of embodying the right to reside with a small r and a small r. You've got to have the right to reside, which means you've got to be allowed to live there. He was allowed to live in Belgium because he couldn't be removed. I dare say Belgian law, like our law, then tries to embody that. We conceptually think if somebody can't be returned, we have to give them a rather grudging form of leave to remain, namely discretionary leave to remain, because you've got to regularise that position in some way. But that's a matter of domestic law, how you regularise it.
Well, my lord, can I put it this way? My lord's absolutely right that there wasn't such an issue about Mr. Zambrano being returned to Colombia. So in other words, there wasn't a decision saying you now have to return to Colombia. If you don't leave within 28 days, we'll put you in handcuffs on a plane. And again, the court's very familiar with cases where that arises. And indeed, KA, of course, was a case where you had a return decision. So you don't have whatever the Belgian equivalent of a removal decision here or a return decision in KA was. But KA was Belgian, so it would be a return decision. But what you have instead is a finding, first of all, he's not a refugee. But because of the situation in Colombia, he can't be returned. The grudging acceptance of presence, if I can put it like that, that my lord refers to. Toleration, I think, is what the Germans call it in German law. There are various different concepts in the different states. The reason his lack, though, of formal right of residence becomes an issue is because without that formal right of residence, something more than simply toleration, he cannot lawfully work.
Well, exactly. That's the point I'm
making. So yes, my lord, I'm sorry if I've been obtuse in getting there. My lord's absolutely right. Zambrano is a case about working in that sense. But the relevance in the employment context does derive from the absence of formal immigration status.
From the fact that the Belgian law, we have to go back and look at it, remember what phrases we used. Belgian law basically said you can't work unless you have a right, what they call a right to reside.
Exactly.
It's all about immigration status, isn't it?
Status, exactly.
That's ultimately what it's all about. And the question depends on whether or not somebody's got immigration status in the host member state, and what rights flow from that. And in Zambrano's case, he didn't have any immigration status which would have entitled him to work, which meant that he couldn't provide for his family, and therefore the argument was, well, the family would have to be compelled to go elsewhere with him because they couldn't properly enjoy their rights of residence because there wouldn't be any food on the table.
Exactly. My lady's got it exactly. And it's still, none of that is an answer to the point I take against Mr. Justice Mostyn, which is that he's wrong to focus on this as in some way meaning that rights of residence domestically don't prevent the Zambrano right from arising. The court was looking.
Because they confer immigration status on the person concerned.
Exactly. My lady has a point. And of course, if Mr. Justice Mostyn were right, then everything at paragraph 39 and onwards, which has spurred so much litigation in this court, now the Supreme Court, the Grand Chamber in Luxembourg on multiple occasions now, and many other courts throughout the European Union, would be completely OTOs, one might think, or would be on a completely false basis. So we say that first pillar for his findings is flawed. Second point is what he says about the long-term nature of the right. And again, that flows in part from how he views the facts of Zambrano. You'll see he sets out the relevant paragraphs from Zambrano, 42 to 45, at paragraph 21. At paragraph 22, he says this: now, it seems to me obvious that the court was talking about the grant of a long-term right of residence and a long-term right to work, at least, those words are important, at least while the children were minors. Now, I pause there. There's nothing in the cases that says anything about the duration of the Zambrano right, because it would turn entirely on the facts. Now, it may well be.
Child could be 16.
Child could be 16.
Yes.
Equally, if the child is 16, there may not be a need to grant any right of residence.
No, because they may have the education rights anyway.
Well, exactly, they may have the education rights. There are lots of situations where older children who are still minors but approaching the age of majority are able to move without the kind of parental support that they need at a younger age. The point put to me in argument earlier on is, of course, that often Zambrano is really going to affect very minor children because you won't be able to engage Texira, Ibrahim, those kind of derivative rights. And yet you're so young, you can't be expected to live alone. It's simply impossible. So it will often be relatively long-term. But when he says at least while the children were minors, That is simply, in my very respectful submission, impossible to understand.
Well, once they're not minors, there's no Zambrano right
No,
anyway.
exactly. Unless you're into the sort of Patel situation.
Yeah.
It's a wholly different situation.
Incapacity and the like.
Exactly.
Yes, I mean, the term of the right will simply depend on the term of the, let's call it for short, dependency, which will depend
Right.
largely on the child's age.
Exactly.
I mean, you can imagine odd circumstances which would terminate it before they're 16 or 18, but generally, if they're 5,
Yeah.
the Zambrano right will be 10 years plus. If they're 15, it'll be a year or 2.
Yeah.
Yes. I think what he may have been getting at is this, that is the only thing that limits the right, i.e. the term of the dependent. So it's a continuing right.
Yes.
It's not one which will be met, I think maybe what he's trying to get at, by a grant of 2 years limited leave. Suppose you have a 5-year-old child, a 2-year-old child.
My Lord, I see that, and I can see that's one way, my submission perhaps slightly generously, of reading that.
Yes, well, it's not very well expressed if that's what he meant, but let's assume.
But if that is the case, there can be no objection to a limited grant of leave on Zambrano terms, and usually Zambrano rights are granted for, I think in this case it was granted initially, because of course Ms. Akinsanya did have a Zambrano right to begin with. It was granted, I think, for 5 years, so that's fairly standard.
You haven't shown us regulation 17, or was it 20? Anyway, in the residence card provisions
Yes.
say, if I've remembered this rightly, that the default thing is you get 5 years.
Yes, exactly.
Subject to the Secretary of State giving some lesser period.
Yes.
And I have rather assumed, there might be other odd circumstances, but the paradigm of the case where the Secretary of State might give a lesser period is where the child was 17, say.
Quite.
And you would say, well, only 1 year.
Exactly.
I can't think of any other circumstances in which the Secretary of State would properly do that, but there might be one.
Yes.
So the point, as it were, to take against, well, this is, I suppose, a point about our domestic implementation. But in our domestic implementation, the Zambrano right is, as it were, formally recognised for, let us say, 5 years. But of course, it would have to be renewed at the end of the 5 years.
Exactly. And the purpose of recognising it for 5 years and being permitted to recognise it for, say, 5 years only is that circumstances change.
Yes, right.
One of the points made in what I think...
If circumstances change before the 5 years, there is provision somewhere for it to be withdrawn, isn't there? I'd be surprised if the Secretary of State has to... Secretary of State generously thinking it's likely to last for 5 years, gives you 5 years, but then something sad, the child dies, say.
Exactly. There's 2 points in response to that. One is that the right, as in with all EU rights of residence, the residence card is only declaratory of the right.
Yes.
So cases like Dias and the old case of Breuer, very old case now, which make that clear. That's an absolutely consistent principle in EU law. I should say things are slightly different with the EU settlement scheme, but not in a way that affects this case now. I'm not going to get into any of that detail. That's the first point. And the second point, my lady says the mother may move, the father may move to the States with the child. That's right. And one of the points made in the Advocate General's opinion it's the Finnish case of O, that I can't pronounce the full name of, is that EU law rights of residence don't amount to putting a child under house arrest in the territory of the Union. It's a very colourful phrase or example given, but that's exactly what that encapsulates. So there are plenty of situations recognised by the courts, of course, where parents for legitimate reasons move to work, move to study, move for whatever.
Well,
you have that point.
But to come back to what I was putting to you.
Yes.
A Zambrano right, ignore what may be a red herring for the reason you've given, what the duration of the res card is.
Yes.
It is indefinite, or indefinite in the sense it is only ended by the end of the situation which gives rise to the right.
Well, my lord, I wouldn't use the word indefinite, but
right.
The way your lordship put it secondly, yes.
Okay, well, I'll settle for that. Just try to think of a single phrase for it.
Sorry.
So it has a temporal limitation
Yes.
based on
Yes, I'd accept that.
Whereas, at any rate in the UK, leave to remain, anything short of ILR, will have a, in this sense, arbitrary limit. I'd say a limit not reflected, not reflecting the underlying nature of the right. Now, if that was his point, which you say may be rather generous reading, what's the answer to it?
So if that's his point, then the answer to that is paragraph 73 to 76 of IDA, because what was an issue there was a limited renewable residence permit under domestic law. It's exactly the point. So even if, reading the judgment generously, that's what he meant, the EU jurisprudence is against him.
And I suppose you can see the logic behind that, because when the limited domestic right comes to an end, there's nothing to stop you then applying for a Zambrano right, because there might be a gap.
Exactly. So if you had precisely, Melody.
So you can't say, arguing backwards, well, why not give him the Zambrano right from the very onset, because it's a bit of a waste of time to wait. No, the CJEU says if you there's no gap to be filled, there's no gap to be filled. Exactly. You wait until the gap arises and then you fill it.
Exactly. And
indeed you don't, I see why Melody put it this way, but you don't actually apply for a Zambrano right. You get a Zambrano right.
Yes.
It arises automatically.
Yes.
You may then need to apply for the paperwork so that you can show it to everybody, but that's not the essence of the situation.
I think that's why Ms. Smythe very sensibly passed me a note saying don't say defeated. It doesn't arise in the first place. Right.
Yes. Incidentally, a small point, do you have to pay for a Zambrano residence card?
You have to pay for the application, as I understand. £65 for the application. For the application? Yes, for the application. Mr. Lamont.
Therefore, you're in a sense paying for the card.
Yes. But, yeah.
Okay.
Well, that's absolutely right. And of course, Appendix FM leave is usually granted on a 10-year route to settlement, as it's called now, which means ILR. And that's, of course, what Ms. Akinsanya had. So in terms of the ECJ analysis and the gap-filling necessity, there isn't one. She applied, of course, for the Appendix FM leave specifically to get around, and I don't say this in any way disrespectfully, it's a simple legal fact. She couldn't claim benefits with Zambrano leave, but she could with Appendix FM.
Yeah.
So one can understand why she did it, a perfectly legitimate thing to do. But it means that Zambrano isn't met.
Okay, so that's the long-term nature point.
That's the long-term nature. The third one I can take very briefly, because I've done it in the cases. It's the distinction between EU rights of residence and domestic rights of residence. That's at paras 30 to 35 of his judgment. And you'll see there what that's dealing with is the A case. Now, I've already given you the answer, which is that, as a matter of principle, there can't be any distinction between the right of residence arising in EU law and national law, because either way, there's no gap to be filled as a result. But if there is a need for authority, it's either.
1 second.
There is one potential wrinkle to that, which is that there's nothing to stop the domestic legislation giving you better rights than the ones that you might enjoy under EU law.
My lady, that's absolutely correct. But of course, then one looks at what it is under EU law that's being protected.
Yes.
And it's the enjoyment of rights as an EU citizen, the most fundamental of which is, of course, the ability to move around the Union and reside freely in the member states. That's why I went from Article 20 to Article 21, because you get the linkage there. And so in those circumstances, the fact that you might have more beneficial rights in domestic law means that if you happen to qualify for those, you'd be well advised to apply for them. But it may be that there's a longer route to settlement on them. So here it was 10 years, whereas obviously there was an application here on the basis that she'd had her 5 years as Zambrano care, as she was saying, would have done, and so wanted to have the ILR that came under the settlement scheme. But the point is whether the rights as a citizen are met. That's the issue. Well, I wasn't proposing, given what I've already said about NA and IDA, to say any more about those passages. I think I've made submissions on that already, and I don't want to repeat them. Then, paragraph 36, my fourth and final point, Here, Mr. Justice Mostyn says, I disagree that the only consideration is whether absent the grant of a Zambrano right, the applicant would be compelled to leave. He's given his reasons above. Disagrees that the source of the alternative right is material. I've explained why all of that is wrong. The issue is compulsion, and that was abundantly clear, with great respect to Mr. Justice Mostyn, from the cases that were cited to him. My lords, my lady, those are my submissions on ground one. We say for those reasons, ground one of our appeal is made out, and that Mr. Justice Mostyn has misunderstood the nature of the Zambrano right, and what he says about it is wrong. So we respectfully ask the court to allow the appeal on ground one. Now, ground two, as my lord indicated, I can take very briefly indeed. It is substantially set out, and in a sense, over to the court for this part, really.
Well, right, you want to say what's wrong?
but
Well, it seems to be obviously wrong with your submission.
I shouldn't have said that. That was very unwise.
Well, is you can't invoke the Mar leasing principles of conforming interpretation, because those are confined to a situation in which the domestic legislation would otherwise fail to implement. And all that fail to implement the EU legislation. And the case law about that is, it seems to me, and obviously to coming back, beside the point. You're dealing with a different situation, which is the presumption, what you would characterize as the presumption against gold plating. But that is, say, giving more than you're obliged to give. But there is no formal presumption to that effect. You have simply got to look at each case and see whether the natural reading of the words is displaced by the fact that the Secretary of State can't have intended to give more than he or she had to. And that's the message of Nolan.
Yeah.
And so we've simply got to look at the circumstances in this case, and the starting point is one that on ordinary domestic principles of construction, if you say, here's a right, but you may be an exempt person in certain circumstances, and those circumstances say, if you have indefinite leave to remain, that, other things being equal, suggests that you're not an exempt person if you have limited leave to remain. So you start 30 love down, if not 40 love down. Then you're looking at, yes, but the government can't have intended to give more than it had to. Well, there has to be some quite strong reason to believe that that's the case. And I can see reasons why, even if you're right about ground one, the Secretary of State might have intended to make a distinction between indefinite leave to remain, where someone is absolutely, clearly doesn't need a Zambrano right because it's all absolutely unconditional. They can do whatever they like, they can stay forever and work as much as they like, and definite leave to remain, limited leave to remain, where that is not the case. We needn't argue, or you may want to argue about whether that's a necessary distinction, but it's not an irrational distinction. And it would have really to be something like an irrational distinction before you got into INCO territory, which is the territory you really have to be in. I'm sorry to put on, but because time is short and
yes,
you gave me that invitation, I thought it would be as well if I rolled up all your difficulties.
That's very helpful. I feel like I'm at the bottom of the seat, so looking up now. But I have to say that. But my lord, to be clear as well on INCO, we had. Obviously, I added the INCO references to the skeleton. I didn't argue the case below. Yes. INCO wasn't an issue below. So I'm acutely conscious that INCO isn't a point that Malone friends have dealt with or had to deal with before. So I mentioned it to show the scope of the powers that the court has.
In a way, INCO is more of a problem for you than for him.
But I'm not relying on INCO in that sense,
right,
my lord.
Okay.
If I was relying on INCO, I'd have to meet the very specific criteria in INCO, and they're not straightforward. I accept that. A rectifying construction is not one that any court would adopt easily. I fully appreciate that. The purpose of referring to income, as I say, was just to show the scope of the powers of the court, which I know the court's obviously well aware of, in construing legislation. Our point is that there was no intention to gold plate here, and that a conforming interpretation against that background is not only possible but appropriate.
But we've got to look, intention, the factual intention of the Secretary of State is irrelevant. We've got to look at what he or she legislated. Of course, looking at it, like all construction, in context. So
yes.
that may shed some light. But I just want to rule out any reference to the intention of the Secretary of State in the direct sense.
I'm not going to labour the court with making arguments about what the Secretary of State intended to do in that sense. I know that wouldn't get me anywhere today.
This all turns on the explanatory.
It does. And that's the context. The context is the explanatory note and explanatory memorandum. Can I take the court back to
Yes, please do.
They do encapsulate it quite well. So it's tab 1 of the authorities bundle at the back of the 2012 amending regulations. And starting with the note, page 7. The second paragraph I asked the court to look at, I'll just read the first few lines. Paragraphs 2 and 3 of the schedule to these regulations give effect to the ECJ.
Sorry, which page are we on?
I'm sorry, page 7, my lord.
Yep.
Paragraphs 2 and 3 of the schedule to these regs give effect to the ECJ's decision in Zambrano by amending regs 11 and 15A in order to confer rights of entry and residence on the primary care of a British citizen residing in the UK, and where the denial of such a right of residence would prevent the British citizen from being able to reside in the United Kingdom or an EEA state. Now, in my submission, that is absolutely consistent. I'll come to the memo in a moment. That's consistent absolutely with the cases I've shown the court this morning, which deal with being forced to leave or compulsion. It's the same analysis. So that's element 1 of the context. The second element of the context is then paragraph 7 of the explanatory memorandum, and that's over at page 11.
Yep.
And you'll see paragraph 7.2, further amendment required to give effect to Zambrano. That judgment created a further derivative right for a citizen in that position where a refusal to confer such a right would force the EU citizen to leave the EEA. And again, in the UK, the judgment therefore enables a primary carer of a British citizen to acquire a right to enter and reside whilst they remain the primary carer, and where the refusal of such right would force the British citizen to leave the EEA. So the language is force. It's the same language in substance as compulsion. Now, that's the contextual intention, contextual material. That is consistent with compulsion in the cases. It's inconsistent with simply looking at whether somebody has ILR and not a limited leave to enter or remain. And as my lady said, that really is the context. That's the material I can rely on.
But couldn't. Well, I want to see how this works out in practice. In asking, not leave out the EUSS context, which is irrelevant for this question. In deciding whether you have a Zambrano right of residence, one thing that goes with it is the right to a Zambrano residence card.
Yes.
If Regulation 16 does, suppose you have someone who already has limited leave to remain, but applies for a Zambrano residence card under whichever, is it Reg 17 or Reg 20, doesn't matter. The logic of Mr. Cox's position would have to be that they would be entitled to both, or they'd have their limited leave, they'd also be entitled to a Zambrano residence card.
Yes.
Is that so terrible?
Well, my lord, it's not a question of whether it's terrible, but it would be, the issue would be that no right arose the Zambrano residence card.
No, it's just a
There's no
way of
gap to
testing.
fill.
I suppose
Yes.
it's a way of putting flesh on the bones that you have two rights at the same time.
Well, it would get you around to preempt you. If you had both Appendix FM leave,
Yes.
which would entitle you to benefits, and a Zambrano residence card, which would enable you to work, it would defeat your Zambrano
It would, exactly.
right.
It would be mutually
But they
inconsistent.
cannot live together.
They can't. Because with the
You
one
can't
hand,
choose between one or the other.
yes. Now you get the right to work with Zambrano, of course, but that's why, in a sense, they're complementary in that sense. You either have you can have your Appendix FM, right, if you satisfy the conditions for that, and of course that's not necessarily an easy right to gain either, but it's different, rises on different bases. But once you have that, you have right potentially to benefits. At that stage, you're not going to, or at least you're not excluded in the way the Zambrano care is.
Well, I'm wondering,
Completely
yes, I'm
inconsistent
wondering in
with-
one sense,
to have the
a lady
Zambrano right.
says they cannot live together, but they don't give you inconsistent rights, do they? It's just that you don't need to invoke one right. For example, supposing if you have been given conditional leave to remain, one of the conditions being you don't work, you will say, well, thank you for the leave to remain, but which may, but I, let's imagine a situation you've been given leave to remain for 5 years, and
Yes.
your Zambrano right will come to an end after 3 years because your child doesn't grow up.
Yes.
I agree this isn't a very likely factual scenario, but it tests it in principle. But you haven't got the right to work during those 5 years. Can't you say, I am going to rely on my DLR, my limited leave to remain, because that allows me to stay here for 5 years. But for the first 3 years of that, I'm going to also rely on my Zambrano right in order to work.
My lord,
Is that it's a very unlikely scenario,
Yes.
but I can't think of a more practical one. But conceptually, why can't you, as it were, pick and choose between the ones that give you the particular benefits?
because the fact that you've got your DLR for that initial period means there's no gap to fill for Zambrano.
There is a gap to fill because you're not allowed to work.
But you would have a right to benefits. You wouldn't be excluded from benefits.
Well, is that the same as the right to work? I'm not sure it is.
Well, you would be able to apply also, and this is, my lord, the point I wanted to check over the lunchtime in German, if I may. But in my submission, you would be able also to apply at least for the right to work. I'm getting a note here. And I'm told that under Appendix FM, what's the issue here, usually you do have the right to work.
Yes, I'm sure that's why I said it's an unlikely situation.
Yes.
I was just trying to tease out, so I haven't quite understood why the model can't be, you've got two rights, one of which, or a right to two rights. You've got a domestic right, but insofar as that is not as good as the Zambrano right, you've got that as well. It's true that in one sense the Zambrano right doesn't arise until there's a risk of compulsion of being compelled, of the EU citizen being compelled to leave. But it's still there in the background.
Well, my lord, in my respectful submission, no. My lord says in one sense it doesn't arise until one has compulsion. In no sense does it arise until one has compulsion.
It's a right to a right, and you say there is no such thing.
Exactly. And I know citizenship is sometimes conceived of as the right to have rights. I think the US Supreme Court takes that approach, and it's been borrowed here, and FAM and whatnot. But the point is, if you don't have the compulsion, there is no Zambrano right. You don't have a right to get it. All you have are your rights, important as they are under the treaties. Zambrano steps in to fill any gap, but the gap is created by a situation of compulsion.
Yeah.
If you're not in that situation...
So we are in a pure situation in which you say that is absolutely clear, and it's clear from the legislative history, even without this, that it's intended simply to embody the Zambrano right. But the draftsman has, as a matter of language, given you rather more.
Yes.
It is you say you can't rely on INCO, but I mean,
Well...
isn't it INCO or nothing? It's perfectly clear what the draftsman has said.
Yes. I hope my lord can see why I was reluctant, in one sense, to raise INCO, because I'm conscious of not being unfair to my other friends in facing them with an argument on appeal, which they didn't have.
Well, that sometimes happens. They have to live with that.
It does. But we've
But
raised
it is a starter is that Regulation 6, this is really what it boils down to. Regulation 16, speaking for myself, if you're just looking at it without any background, it's pretty clear. It says it's ILR, and that means it doesn't mean any other form of LR.
Yeah.
You say that can't be what they really meant. Can't be. Look at the mischief. They've just made a mistake. But the vehicle for making such an argument is INCO.
Well, my lord, if that's the vehicle, we satisfy it then. We have at least raised it, and we raised it.
Yeah. Well, let's hear what Mr. Cox has to say.
Yeah.
And I may sound very definite on all this.
No.
I'm not. I'm just, because time is short,
No, of course.
cutting to the chase. That's how it seems to me at the moment. It may not be how it seems to my lord or my lady, but we know what you say anyway.
Yes, and we've set out the INCO submissions at paragraph 51 and onwards. Obviously, the three conditions in INCO: intended purpose of the statutory provision in question, the court has to be sure of; that by inadvertence the draftsman failed to give effect to that purpose; and the substance of the provision must be clear. Well, we say we do satisfy all three of those conditions in INCO.
So you're going back, although you didn't want to go there, you are, if necessary,
If necessary.
asking for permission to allow INCO, if you need it.
If I need it.
You have to show it's a plain case of a drafting mistake.
Mistake, yes.
Speaking for myself, I don't think you get any help from the explanatory note and the explanatory memorandum, because they say correctly that we are required to give effect to the CJEU judgment in Zambrano. So they were. And if you're right on ground one, what they say as to what Zambrano requires is correct, that you must otherwise be compelled to leave. But that doesn't, to my mind, show that it's a plain case of a drafting mistake if the regulation is a bit more generous than the CJEU required.
Well, my lord, my response to that would be that the language of the explanatory note and memorandum does assist me by context, because it shows what was meant by implementing the Zambrano right, and it's the compulsion to leave or being forced to leave. Now, that is completely
No, I see that, but
inconsistent with the language.
No, I understand that.
Yes.
But the explanatory note and memorandum don't go on to say, and it would be constitutionally odd if they did go on to say, mind you, we're not going 1 millimetre beyond what the CJEU require.
But then, my lord, the question becomes one of gold plating, and if one has gold plating legislation,
That's what gold plating is. That's just what my lordship put it.
Absolutely, but if one is going to gold plate, usually, and we've set out the government guidance on this, one does so expressly, because of course there are implications usually for resources, for extensive over-provision of EU rights. Now there's nothing, and indeed not only is there nothing which shows it was the intention to gold plate, but on the contrary, there is material in the note and memorandum which shows the intention was to do absolutely the strict letter related to compulsion, and the cases have made that clear as well.
But the point that's come out of the submissions that I've heard so far on this is it's not, you're saying, I think it's not just a question of being a bit more generous, but it is actually adding rights which are inconsistent.
Exactly. And that's why it's so critical. So it would be
to understand why they're inconsistent.
Because, my lord, if somebody had limited leave, and of course if I'm wrong about this, then I lose on both grounds, and I embrace that, I fully accept that. But if I'm right that a limited right of leave under domestic law, for all the reasons I've already given, means that Zambrano rights do not arise, then when the note and memo say we're giving effect to the judgment in Zambrano, there is a clear drafting mistake, because they couldn't have given effect to Zambrano in a situation where a Zambrano right wouldn't arise. There's simply no need for it. And I would ask the court to bear in mind, again, the submissions I made at the outset about this being a right that, although it's at the heart of EU citizenship in a way, it's very much at the periphery of EU law as well. And it is a very controversial right. It's exactly the sort of issue, and bear in mind how long the government took to decide what to do about Zambrano. Now, it might be said against me, well, it took a long time and they then got it wrong. Except that point is the obvious corollary to my submission. But if it's a drafting mistake, it's a drafting mistake. And in my submission, there is no indication at all that the government intended to gold plate, and no indication from the relevant contextual material, which is the explanatory note and memo, that this is anything other than a mistaken attempt to implement Zambrano. My Lord, and my Lady,
Well, no, we let you
very
go on.
generous.
It's more sensible to finish on this, Mr. Croxton, where we are.
Yes.
Could I just flag up one other constitution? INCO is a well-known case on the interpretation of a primary statute. And there are all sorts of rules about how you discern the intention of Parliament. Seems to me it's a bit dangerous if what is being interpreted is a statutory instrument to admit evidence from the civil servant who was involved in drafting it and say, well, it's easy enough to see what the interpretation of the secondary instrument is. Here's the guy who drafted it.
My Lord, I think my Lord refers to the witness statement of Mr. Lamont.
Yes.
Yes. My Lord, as I understand it, that witness statement, and I appreciate it may look a little odd in a judicial review like this to have that. That witness statement, as I understand it, was submitted when the case looked rather different from what it does today. So there were a range of grounds that were before the High Court, and there were a range of issues before the High Court, and there were a range of questions that had been asked by the claimant on the claimant's behalf. And Mr. Lamont's statement, I'm instructed, was intended to meet some of those questions and respond to some of the other issues that were there. I entirely understand my Lord's point, and I accept that I can't, in a sense it's my Lord the Vice President's point as well, that what I can't do is stand up and say, well, look what the Secretary of State's civil servant intended through evidence from him. I don't rely on it for that purpose. What I rely on is the explanatory note and the explanatory memo. I accept that, I entirely understand and accept the constitutional point my Lord puts to me, but that's why I focus on the context that my lady highlighted, the note and the memo. I'm very grateful for the court's indulgence.
I think. Are you happy just to have 3/4 hour lunch?
Yes.
Yeah. Let's sit again at 2.
Very grateful, my Lord.